in a single PDF format, and the documents were not, bidding documents were not digitally signed, or the petition is dismissed. But we give you liberty to approach the civil court for compensation if you feel. Yes.
Well, I may be permitted to move an urgent application to the registrar at 2 p.m. my lord.
Oh, what is the urgency?
My lord, actually, the petitioner is the grateful employer, was the grateful employer Wipro, my lord. Now, the labor commissioner has already issued an order for payment of about 83 lakhs to the petitioner as compensation and back wages, my lord. The authority has defied that order, my lord, already, and the proceeding has been initiated for recovery of demand under Section 8 of the Public Demand Recovery Act, my lord. Once a certificate has been issued under Section 15, my lord, for payment of the compensation and amount, then the authority cannot sell or transfer the property within the district where the property is situated. In this case, my lord, the Wipro has already taken over by the ITC. Now, ITC has taken a permission, my lord. I have come to learn from the office of the deputy commissioner, obtained the sale permission, my lord, to sell the property to third party. So unless, my lord, the sale is not stopped, my lord, I will not be able to recover the amount. Already, since the bucket proceeding is proceeding.
Okay. Okay, permitted.
Your Lordship, this is a humble prayer for listing of writ petition 2899, which was yesterday called for, but due to some medical issues, I had to go out. And in the meanwhile, I cannot track the case because of that not showing of that display board in the website. There were some technical issues.
No, it will not be shown because it has been withdrawn. It is only available in the campus because there was a hacking in the court system, and therefore the NIC has stopped it.
That is why I face that issue. If your Lordship may just permit the case to be listed by tomorrow, or
What was the item yesterday? Item number?
item number 37.
37.
Yes.
When it is listed? After some time, 7th of June.
Yes, that is why it will be a little bit late. If your Lordship just.
Okay, let the court master give a date. Okay, give a mention memo. Yes, Mr.
Okay.
Ali.
Yeah, these are also, item number 18, day before yesterday, I highly implement this on my. I have the necessary item to be listed.
You ask someone to get it listed because it has to be listed.
Yes. Item number 18,
Lordship, in respect of item number 19, Lordship, I have taken consent from the opposite party, Lordship. The matter will be fixed after a week, Lordship.
Okay. You are for?
And for the petitioner, Lordship.
Okay, with consent of the other side, Mr.
J.M. Gogoi, Lordship.
J.M. Gogoi, counsel for the petitioner, pays for adjournment, pays it out, list after a week.
Lordship.
My lord,
Yes.
I pray for listing of this IA for tomorrow, my lord. My lord, the urgency is that
Tomorrow it will not be taken up because there is an election matter tomorrow. Tomorrow matter will not be listed.
then on Monday, my lord.
Give it to the court master.
May I please, your lordship? Lordship, the concern of the other side, I'd like to mention item number 14, your lordship. 14.
Yes.
Mr. P.N. Goswami is out of station for treatment of his son, your lordship. May the matter be taken after 2 weeks, your lordship.
Okay, you have taken consent?
Yes, your lordship. Taken
There
consent.
is an interview item.
Okay, both sides are duly presented. It is submitted that Mr. P.N. Goswami, an additional advocate general, is out of station. And accordingly, prayer for adjournment is made. Prayer is allowed. Intimato passed a list and we studied till the next date of this thing. List after 2 weeks has been for.
Lordship, I have another prayer, item number 11 and 12. I've taken consent, similar prayer, lordship. Mr. P.N. Goswami is absent.
these matters may fix, my lord. Say, my lord, about 2 weeks, my lord, 6th of June, my lord. Matters will be fixed.
Okay,
My lord, along with 6544 of 22, my lord, another matter of the picture, same picture, my lord.
okay, along with 6544
44 of 22.
of 2022.
Obligation.
Make this is a last. Last by seek your permission for listing of the motion matter tomorrow, my lord. Yeah, this
Tomorrow it will not come.
my lord, it's a FPDCL matter and Lordship has heard on yesterday also heard and fixed it, my lord. Connected matters, my lord. This is what. Lordship has fixed it tomorrow, my lord. All the other matters, my lord. For motion. I have also, my lord, cited earlier case numbers also, my lord.
Tomorrow I don't know because it will be very difficult day.
Lordship already 3 matters have been listed tomorrow in the main cause list, my lord.
Today already there are 67 matters. Not commit, make it Monday.
Monday.
67 matters are there or motion.
So same, my lord, same cause of action.
No,
What is
but
the
still
difference?
it will be difficult. Because tomorrow I have election matters be taken up. So Monday.
Please, I'd like to mention for listing for withdrawal from Monday. Withdrawal.
Yeah, please, your lordship. My lord, I can say when an appearing person. Can it be upgraded, my lord, because I'm from Manipur, my lord, and on various occasions in the past also it was fixed for final disposal.
No, we'll take it up. There are only less items. We'll take it up. Mhm.
Highly obliged.
May I please, your lordship. My lord, and I has been filed yesterday, my lord, connected with the Pathat matter. Matter is fixed on my lord 29/5, my lord, Monday. So my lord, maybe connected with this matter, my lord. Highly obliged.
May I please, your lordship. Lordship, I pray for listing of two petition, my lord. It's possible on the first week of June, my lord. One petition is filed assailing the action of the respondent.
First week of June is not difficult. Give it to the court master. All
Alright.
prayers for listing, give it to the court master. He'll have to adjust and do it.
My lord, my.
Mention will not be made. It can be given to the court master. Tomorrow, no matters will be listed.
My pleasure, Lordship. With the consent of the petitioner, I beg to mention item number 8, my lord. My lord, the leading counsel P.N. Kusami is out of session for treatment of his son, my lord.
Okay, you have taken consent?
Yes, madam.
Okay, same. P.M. Goswami. Item 8. After 2 weeks. There is an interim order. The interim order stands extended. Okay.
Deeply obliged.
May I please, your lordship, with the consent of other side, I beg to mention item number 2, password for the day, my lord.
Okay. List after a week is paid for by then counsel for the petitioner. Item 2, Karbi Angalam council.
Fine.
You have instructions?
We have received the instruction, we have already passed the order for demarcation of the land. This is the demarcation of land. They are alleging that we have not passed any order.
Hmm.
Well, there is a civil dispute between the two parties, my lord.
Okay.
So it is a civil dispute, so we can only demarcate the land. And if once the possession, he has not possession.
Okay, that is another thing, but you have done it.
My lord, we have
Okay,
already passed the
okay,
order.
that's okay. Then
I beg to mention for listing of the case, my lord, the matter in this.
give it to the court master.
Daily list, item number 1, motion BA.
You have to call for the case diary. You have case records.
Scan copy, my lord.
Can copy.
Charge sheet, my lord.
Is it available in the earlier record?
No, earlier, my lord, it is long back, my lord, 21/9/22, it was rejected.
No, no. If the case records are there, we can only call for the relevant.
Relevant, up to that, my lord, yes.
Was it available? Do you remember?
My lord, no, my lord. It is long.
Okay. The registrar call for the case records. Scan copy of the case record. In respect of sessions case number 195 of 2022, arising out of Jagir Road PS case number 210 of 2022, pending before the Court of Learned Sessions Judge Morigaon. Along with the scan copy of the last few order sheet, so as to understand the case status of the proceedings. list on today's 7/6/2022.
Three for motion. Item number 3.
In this case, this one, my lord, we had challenged the profiting which has been initiated by the income tax department when moratorium has already been declared. My lord. This is the case.
This case you had cited does not help you, in fact,
Lordship,
that Sundaresh,
paragraph 37 also.
Sundaresh.
Yes,
ah,
sir.
It says that you can only, you see, you can only determine.
Yes, Lordship.
Determine is possible,
Yes.
but the recovery shall be subject to.
Yes, Lordship, we cannot make recovery from the company, Lordship. We have to file our claim before the resolution officer. That can, we cannot be, we cannot be stopped from proceeding. Lordship.
No, that you can't be stopped.
That
They
is,
can raise the claim and actual B that I have said. Up to that much, it is okay. As per the news that Supreme Court.
here, we cannot realize from the company, Lordship. That is clear.
No, they can raise the claim.
Heard. Mr. M. Kotakil and the counsel for the petitioner. And Mr. S. C. Kyal and standing counsel for the income tax department, representing respondent number 2. One will be CUC.
Finance, Lordship.
who-
Architecture.
Mr. R.K.D. Chaudhary and ASGA for respondent number 1. Next para.
I had also submitted one Supreme Court case, 2018.
By filing this writ petition in Article 226 of the Constitution of India, the petitioner has prayed for setting aside notice dated 17/4/2023 issued by the Assistant Commissioner Income Tax, Circle 5, numerical 5, within bracket 1, Kolkata. By which notice was issued under section 148 of the Income Tax Act for the accounting year 2019-20 on the ground that the said authority was satisfied that an income of rupees 7,93,65,393, which is chargeable to tax, had escaped assessment. Next one. The case of the petitioner is that the petitioner number 1 company, that against petitioner number 1 company, insolvency proceedings has been initiated, which is registered as CP number within bracket IB bracket closed oblique GB oblique 09 oblique 2019, and that by an order dated 26/8/2019, moratorium was declared under section 13 of the Insolvency and Bankruptcy Code 2016, and insolvency resolution professional was appointed. It is projected that once a moratorium has been declared, the income tax authorities would be barred from initiating any recovery proceedings. Next paragraph. The learned standing counsel for the respondent number 2 has referred to the case of Sundaresh Sundaresh Bhatt, liquidator of ABG Capital Shipyard versus Central Board of Indirect Taxes and Customs, within bracket 2023, bracket was 1 SCC 472, and it is submitted that the Supreme Court of India has held that while there would be no bar in adjudication of the claim, only in respect of recovery proceedings, the same could be placed before the IRB, insolvency. What is it called? Insolvency,
Resolution professional.
IRC, the resolution professional. That's one. Insofar as they said, next paragraph, insofar as they said legal position is concerned, the learned counsel for the petitioner does not dispute the same. In view of the said settled position, just add that, and nonetheless, the paragraph 38,
57.
57.
57.
57.
Yes,
Paragraph 57 of the said case is quoted below. Next, in view of this settled legal position, the court is of the considered opinion that it would be permissible to the respondent number 2, i.e. the Assistant Commissioner of Income Tax, circle dash numerical 5 within bracket 1, Kolkata, to proceed with the adjudication and bring the said adjudication to its said adjudication initiated by DIN and notice number is 34. I marked it. So and so dated 17/4/2023 in respect of accounting year 2019-20 to its logical conclusion. Next paragraph. However, the respondent number 2, in view of the ratio laid down in the case of Sundaresh within bracket Supra, would be bound to in the event any taxable amount has escaped assessment, the respondent number 2, in view of the ratio laid down in the case of Sundaresh within bracket Supra, would be entitled to refer the claim to the insolvency resolution professional for the purpose of recovery, if any. First one. Accordingly, this reparation stands partly allowed to the extent as indicated above. There should be no orders to cost. Yes.
Melod, I think, if I may say, Melod, that Melod has got the order, Melod has said that he issued a notice under 148. It should be 148A, Melod,
Acha,
148A small b.
Okay, 148A small b.
A small b. They issued notice on that. 17 was passed on and small d. After receiving, but
Okay, okay.
we have changed that, Melod. We have submitted the representation, but they did not consider our representation. That
That's
is
okay, that is
those-
matter
those
of
are-
adjudication. That's a matter of
That
adjudication.
has to be done.
148 capital A within bracket small a.
Much of it, most of that.
Item number 4 for admission.
Yes, ex gratia.
The petitioner claims that the person who passed away
Was killed by
he
miscreants.
passed away due to miscreants. Well, if I may most humbly draw your lordship's attention to page 24 of your lordship's brief. The final report of the police, Miller.
Yes,
During investigation, visited the place of occurrence, interrogated the informant, other witnesses, conducted postmortem of so-and-so and collected the postmortem report. After investigation, it was found that the deceased so-and-so was working in the house of so-and-so and last on 3/1/2020 at about 8 p.m. His dead body was found lying on the PWD road of Boshkata while he was returning home on a walk after working in the house of so-and-so. During investigation, interrogated the local witnesses, also conducted secret investigation, but actual cause of death could not be recovered. On the other hand, interrogated local witnesses, but no proof of enemy was found against the deceased.
This is
After
very
investigation,
important,
case was established under 302, but no clue is found, and as such, I've submitted the final. But it could be a
But if
private
they-
dispute. He might have
but-
entered. It's not
No,
an
no,
act of
no, no,
miscreants.
but if you carry out a secret investigation, that means nobody will know about it, what investigation you are carrying out. Somebody will have to, everybody will have to know that you are carrying out investigation to find out the truth about a death.
Yes, my lord.
It is
This
not
is the
clear,
very
my lord, that he was
important
killed by
part.
miscreants.
On the other hand, interrogated the local witnesses, but no proof of enemy was found against the deceased. This is very
No, but you
important.
see, no, the death must be unnatural.
Yes,
You see, there should be some attack on him. There should be some, the postmortem should reveal,
yes, my lord. Postmortem is annexed, my lord.
where is that,
I have annexed the postmortem. my lord.
where is that?
Postmortem
lord,
says
page
it is
20.
homicidal, my lord.
Page 20, my lord.
Page 20.
He might have had a private
My
dispute
lord,
with somebody.
opinion,
my
my
lord.
lord. In my opinion,
Somebody
the
may have
cause of
attacked
death is hemorrhage and shock following cut injury to neck, which is antemortem in nature and homicidal in nature. Page 20. And vernacular, my lord, at page 22.
Do you have a better copy of postmortem report? Can I, do you have it? This is something I can't read.
No, my lord. My lord, in opinion part, my lord, it is clear, my lord. In vernacular also, my lord. At page 22. In my opinion, cause of death is
Hemorrhage
hemorrhage
and shock following an injury,
cut injury.
cut injury to neck,
Cut injury to neck.
which is antemortem in nature and homicidal in manner.
And the
But
investigation,
Mr. Hussain, some investigation must reveal that he has been killed by miscreants.
yes,
You
sir.
see, is somebody being murdered with the accused not known, then perhaps
Then the Lord,
it will not be a miscreant who is doing it.
Yes.
yes, this is the miscreant, my lord. My lord, come to annexure 1, page 13, my lord. My lord, page 13.
Next.
Is the highest amount, my lord, 5 lakhs ex gratia to NOK of persons kidnapped, abducted by terrorists, extremist miscreants whose age is 18 or above. Highest amount, my lord. 5 lakhs. Of all the categories.
Mr. Sharma will be entitled to compensation. Even if the miscreant could not be identified. You see, miscreant in the Black's Law Dictionary is described as number one, a wrongdoer. Number two, an apostate. And three, an unbeliever. So therefore, if you are if your scheme says miscreant, then even a wrongdoer would be a miscreant. So if somebody is murdered in the road, you still will have to do it.
Murdered in the road, yes, my lord. If I be most, again, going back to the FIR, there's no mention that he was killed by someone. Kindly see the FIR, my lord, page 16 of your lordship's brief.
You see, the only the thing which can help you is that if you can get the copy of the postmortem report, which I can't read. If there it says that there is, you see, only one line says that it is antemortem.
That it says.
Correct. And if the nature of injury also discloses it was a antemortem injury,
My lord.
then it's somebody has killed it. Because it's not a suicidal death, it's a homicidal death.
Well,
If it's homicidal death, you'll have to pay compensation then.
I'll obtain instructions in this regard, my lord, if I may be granted a few weeks time. And also, my lord, the laxity of the petitioner. He is claiming under this, he has not even cared to place his next of kin certificate. Well, the laxity of the proceed.
These are not laxities. Nobody knows that you will question, the government will question the wife's what you call status and want a next of kin certificate.
Next of kin, there's a
Mrs.
reason, my
Sharma,
lord.
you please, I'll give you 2 days time.
My lord,
Correct. By Monday, I can't take it up. Wednesday.
my lord.
On Wednesday, you bring me a circular requiring that next of kin, and you
Well,
will find in
page
the.
13.
Please understand. Let me complete my sentence.
My lord.
In respect of the revenue circulars, next of kin certificate says that it can only be issued for a debt and liability of 2,500. I can't remember it now because long back these were used by me. I don't retain that memory, but where I will find it. But revenue circular says a next of kin certificate is required for debts and securities of 2,500. So if you are arguing on next of kin certificate, you show me and then we'll pass orders.
Well, I'm not arguing, my lord.
No, you see, you are questioning the audacity.
Well,
If you question the audacity of one, that means you are also questioning the wisdom of the court.
No, my lord, not at
No,
all.
no, it
Not
is
at
a
all,
natural
my lord.
corollary, you
That
see.
is not
No,
there.
you see,
That's not there, my
it will be
lord.
a natural corollary because we are all
Not
the
at
part of
all.
the, no,
I may not be
No, no.
misunderstood.
because we are part of the same system.
I
The
may
only
not be
difference is that there is
That
a
is-
barrier, you
that
are
is
there and
not
I am
there.
here.
That is not there. in
No,
me,
no,
my
no,
lord.
but you see, this is a fact.
No.
If you say that it is not there, and therefore we are entertaining the claim petition, that itself, you see, there is a presumption that the court knows the law. I have my, you see, let me tell you, I have my own reservations whether I know law or not.
That's not there.
And for that,
With me, that is
No, no.
not there. Never, my lord.
please hear me. And you see, I take pride in saying that I don't know the law because I am exempted from knowing law. You want to know the source? I'll show you one. A judge is excused from knowing law. Is something you should always remember. Although the Supreme Court says and our court also says a
Not
judge is
questioning
presumed
it.
to know the law. But read this.
Take it for you.
It starts from page 27. Section 57, it ends at 28. In 28, I have given a pencil mark. Because this is something I always
No, my lord.
try to remember.
I will. The only thing, the reason I pointed out the NOK is page 13, the writ
No, you
circular
see-
he relies
No,
on.
no. You see, number one, the government is now opposing the prayer on the ground that he was not killed by a miscreant. So therefore, the reason to produce a next of kin certificate will not arise. If the deputy commissioner says that you produce the certificate and will give you compensation, she will run and give it to you. Now you see 57, facts of which court shall take judicial notice. Correct. Next page, you will find 13 items are there. Correct. After that, there is a proviso. second proviso are marked. Please read loudly so that I can also,
The court is called upon by any person to take judicial notice of any fact. It may refuse to do so unless and until such person produces any such book or document as it may consider necessary to enable it to do so.
correct. So therefore, I am excused of knowing law. I can ask you to bring that
Absolutely,
revenue
my lord,
circulars.
That
No,
is
no, no.
never there, my lord.
I am asking you to bring it.
I will.
Because the revenue circle, once you have dealt with this issue, then you produce the revenue circle with requiring the next of kin certificate. Because then you see, then we'll interpret and say, because if a citizen can be, if a citizen otherwise becomes entitled by virtue of your definition. Now, please see. Now, please come to page 13.
My lord,
This is the notification,
my lord.
right? Now, nature of incidents are given. Ex gratia of people killed by so and so due to cigarette filing, the ex gratia of the next of kin of person killed in public so and so. Ex gratia to NOK, serial number 4, serial number 5, ex gratia to NOK. Financial assistance number 6 to assistant to sustain simple injury. Next is 7, financial assistance though to sustain so and so. 8, financial assistance to person who become permanently invalid. 9, rehabilitation grant to all so and so. So now you see this certificate, your scheme does not say that filing of a next of kin certificate is mandatory before you apply for what you call ex gratia.
That it does not say.
So we'll interpret, once we bring that circular, we'll interpret.
The revenue department circular. my lord?
Yes. Next of kin, you're asking wherever the source be, because I have forgotten where it is. I remember vaguely that it is revenue. It was in the compilation of general circulars, volume 1, volume 2. But those, unfortunately, I stopped reading. It was in the general circulars compilation which I have, but I forgot now. Mr. M. Hussain, counsel to the petitioner. Mrs. S. Sharma, the government advocate, has submitted that in the police report, in the closure report submitted by the police, within bracket, final report, there's no indication that the miscreant was identified. And therefore, it is submitted that the petitioner would not be entitled to any compensation. It is also submitted that the next of kin certificate is not enclosed in the petition. Next paragraph. It appears from the definition of miscreant as provided in the Black's Law Dictionary that a miscreant is number 1, a wrongdoer, number 2, an apostate, apostate, semicolon, and unbeliever, full stop. Therefore, the it privacy appears that as the notification dated 15 November 2014 mentions about persons killed by miscreants. Within bracket, when, as per the report of the police, the killing is not a result of private dispute, bracket close, the person will be entitled to compensation. Next, therefore, on the next date, both sides will be, would be prepared to argue on the in respect of clause 1 of serial number 1 of the notification dated 15/11/2014. In the meanwhile, the government advocate shall also procure the notification with regard to the notification of the circle of the OM with regard to requirement of next of kin certificate. Correct? So next time you'll be prepared to argue on this, be prepared with the case laws. This on when?
In a week's time, subject to the convenience of the son of the
Nice,
court.
5th of June.
Deeply obliged. And only thing, well, there is absolutely,
No, not that, not that. You see,
that is absolutely not
no,
there.
not that, not that. I
That
understand. No, I don't,
That is not there, Malad.
no, no, I don't doubt. I'm,
Absolutely not there, Malad. Whatever I stated,
no, it's
nothing
okay.
at all.
I'm not criticizing you. I'm just saying that I am reminded of
No, Malad.
my limitations also. there.
Never an affront to all that, Malad,
No,
from
no.
my side. Never,
not-
Malad.
I'm not accusing you. I'm just saying.
Never. Like,
I'm not accusing you.
Okay.
18.
My lord, in this case, my lord, we file one impediment petition, my lord.
Who are you?
I am my lord. I am my lord. One Monsing Rongpi, my lord.
Yes,
And
what is your interest?
I file a impediment petition. my
What is your interest?
My lord, some of the land they have shown in the petition, my lord, belongs to me, my lord. And annexure 6, my lord, case.
No, no, you may be owner of the land, but is it a part of the factory premises?
Yes, my lord. Factory.
Then you are not a necessary party.
Yes.
You see, it's a case of eviction and demolition,
Yes.
correct? If eviction is made, then you have a right, if there is a vacant ground, then you have a right, you can enforce it. But in a writ petition, how can you, how far you can contest this prayer about the, in respect of the prayer, you see the prayer in this writ petition.
Maybe may lie in civil court, not in the joining this petition.
It's okay, I'm just trying to understand.
Yes, in page 28, my lord, of the writ petition.
Yes. Why the eviction drive carried out by the respondent under the supervision of circle officer should not be adjudicated. Correct.
That page, my lord, 28, para 59, my lord. There is a, my lord, another proceeding going on, my lord, WPC number 8462 of the 2022. my lord.
Oh, Acha, your name is included here.
Yes, my.
Mr. Chaudhary,
I don't
his
know.
name is there in
Yes.
para 59. You have
My lord.
introduced that, his name you have introduced in para
Yes,
59.
my lord.
In respect of another petition, but his name has been introduced. Page 28, para 59.
Yes, my lord.
That is with respect to
No, but whatever, in this petition, once a mention is made,
Yes.
you'll have to impede him then.
No, lordship may impede him. That is not this. Only
Ah.
thing is, my lord, my factory is, my lord, under.
No, so we'll
seizure.
take it up. We'll
Yes,
take it up. We'll impede him, but we'll continue with the matter.
yes.
Okay, we'll impede,
My lord,
but we'll continue the hearing.
My lord, would your lordships kindly give us a little opportunity to file an objection to their application? my lord?
The application,
Yes,
you want it? Okay,
yes, my lord.
okay.
Meanwhile, lordship will consider, lordship will keep that pending, my lord, keep that open. But kindly
Yes,
come to the interim order passed by this honorable court, my lord. In fact, we had two prayer, one prayer was not considered. If a lordship would kindly come to order dated 4/5/23, my
No,
lord.
then, Mr. Chaudhary,
Yes,
once this impeding application is there without disposing it off, if I enter, that would be not good. You choose a short date, whatever you want, we'll fix it and we'll take it up. If you want, we can fix it on 2nd or 5th, whatever is convenient to you.
so my lord, our only concern is, my lord, it's a going concern, my lord, because of the seal. My lord, we have not been able to operate the factory.
No, I understand, but you see the impeding application being there, it would be improper to proceed in
Okay,
this
possible
order.
implead them, my lord. Possible implead.
If I impede, then I can proceed
Yes,
with the
yes,
matter.
yes, yes. Possible implead them.
I may be allowed to call my senior, Mr. NNB Sudhir.
Yes.
Yes, sir. I'm not here, I'm no problem. Yes. My lord, may kindly come to order dated
Just,
4/5.
just a moment. Let me dictate that order.
Yes. Implement on petition from action, man.
It's not there.
It's not before your.
It
It was
has to
called, my
come.
lord. It's not a saying it was called.
It was called.
I kindly
Okay.
mention policy.
At 2
Yesterday it
o'clock,
was mentioned.
at 2 o'clock then,
Yes,
at 2 o'clock we'll take it up, but you make your submissions
my lord.
in the winter, but I'll consider after passing this order
Yes, yes,
in
yes,
impleading application.
yes. My lord will kindly come to that order, my lord. 4/5/2023. I'll have your lordship's kind attention to the last para. Our board Pujari Learned Council. Order. First para, my lord, of order dated 4/5/23.
Yes.
Mr. R. Borpujari Learned Council appears for the respondent number 1. And Mr. K. Gogoi as well as Mr. N. Goswami Learned Council appear for the respondent 2 to 4. They submit that petitioners have illegally occupied government land adjacent to the land owned by the petitioners by way of encroachment. Accordingly, construction made over enclosed area of land has been demolished. They further submit that no demolition will be undertaken on land covered by Schedule A and B. Issue notice, etc. On considering the submission made by the Learned Council for the parties and on perusing the documents on record, respondents are directed not to take any action in respect of any construction made by the petitioners on land covered by Schedule A and B to the writ petition. My lord, they say whatever government land that was under our occupation allegedly, my lord, that they have, my lord, cleared and demolished, whatever concern. But they also say, my lord, that factory is located over, my lord, A and B land, and they have no plans to do anything. My lord, in fact, our factory is in A and B. Now, please come to page 249, my lord, of the writ petition to show, my lord, the nature of, my lord, restraint that has been put.
1.
Page 249 of the writ
249.
petition, my lord.
Yes.
Annexure 47. Kindly see, my lord, they have put a barricade. So, my lord, the rear portion is Schedule B and the front portion is Schedule A land. Now, my lord, my cleanly is located in, my lord, Schedule A, and limestone and all are stacked in, my lord, Schedule B land. So, my lord, because of this, we have not been able to operate the factory, and the
No,
conveyor belt is
this-
in between both.
No, this 249 page,
Yes.
in the middle, there's a postal Sarkari Bhumi.
Ah.
Yar Vitor Pravek Nikhed.
Ah.
That means that land where the barricade is there,
Yes.
beyond that, everything is government land.
They want to say, my lord.
Huh.
Now, my lord, we should be allowed to enter. My lord, this factory was set up, my lord, after taking all requisite permissions, my lord. My lord, the director of the company and my lord scheduled tribes, there is absolutely no problem, my lord. Now, if there is any portion of the land which according to the civil authority, my lord, the land is, government land, that they have already taken action. It is not their case, my lord, that they themselves say, my lord, Schedule A and B, they have no plans to do any action. And in fact, this is the Schedule A and B land. Now, because of this, my lord, our manufacturing activity has come to a standstill.
Mr. Handy, can you get us your demarcation, what do you call, the demarcation, what do you call, report?
In fact, my lord, on last occasion, the learned single judge of this honorable court also suggested, why don't you, in presence of the circle officer,
Yes.
demarcate the land and start it?
That's
was
what I'm-
suggested by this honorable.
That's what I'm coming at. Because you
We
see,
are
if
paying
it's a
83
factory,
crores of revenue annually to the state, my lord.
if it is a factory,
Ah.
you should do it urgently. Within 7 days, you make a demarcation. And Mr.
Yes, ma'am.
NNP Chaudhary,
Yes, ma'am.
insofar you are concerned, you are a landlord. For the present, although we are including you in your application, but we will not permit you to, what you call, raise your private dispute, if any, in this court.
That is not actually correct, my lord. Tax is something different, my lord. That was not projected. There are 2-3 cases we have appeared, my lord. Lordship, first I have to show one thing. Of course, my learned senior friend was not appeared on the first time. 4 salaries who has been annexed here is the forced document. This is a report of the circular.
No, you see, it may be forced. Let us
Yes,
take it. All the negatives against the petitioner will
Yes,
accept
sir.
it. That you are saying everything which is all negative to
my
the petitioner, correct?
Actually, my,
But still,
yes,
in a prayer in this writ petition,
yes, ma'am.
you will not be entitled to any relief.
May I come, my lord?
Yeah.
1 minute, my
Yeah.
lord. There is a PIL is going on, my lord. Actually, my lord, this company Purbanchal Cement is not constituted all the tribal people, my lord. And there is a law of the land, there is an order of the division bench directed to evict all this person from that particular place who has transfer, uses, possess particular plot with the comprising with tribal people, with non-tribal people, my lord. That is the game, my lord. And what happened, my lord, here in the instant case, my lord, earlier there is an order passed against Purbanchal, my lord. Honorable Justice A.K. Bujarbura, my lord. That order was when it was, my lord, filed, the specific date has been given to do all these things, my lord, because there is a division bench order, my lord. And that was not done. Thereafter, another petition has been filed asking for cadastral map. Your lordships know the cadastral map of Guwahati. It is not possible to give all these things, my lord. I am not going all these things, my lord. Problem is that, my lord, that eviction has been carried out. I think that is the order of the division bench, my lord. And division bench affidavit has been filed by the, my lord, Deputy Commissioner, my lord, because the court has repeatedly asked the court number in Poddut Kumar Bora. That order is also available. Repeatedly asked why have you not carried out the order. Then what happened, my lord? He has stated because there is petition has been filed here. That is why we could not carry. Your lordship, kindly go through one minute.
Mr. Chaudhary, just I'm trying to understand your
Yes,
submission. You see, the division bench is asking the state authorities why they are not carrying out eviction, right?
Yes, my lord.
Do you think the eviction will be carried out without giving a notice?
As per my lord, government land, my lord, notice is not necessary, my lord.
No, that is
Yes,
okay. This
yes, ma'am.
government land has already been evicted,
Yes, my lord.
correct?
Yes, my lord.
Now what remains is the private land,
Yes,
where the
ma'am.
government has no control,
Yes, my lord.
save and except to evict him by due process of law.
In accordance. My lord, your lordship, kindly go for 1 minute with the order of Poddut Kumar Bora, my lord. Land has been mentioned here, my lord, Sonapur Circle. And what is the statement in the affidavit, my lord? Your lordship, kindly go 1 minute, my lord. Thereafter,
No,
your
no,
lordship-
giving 1 minute or 1 hour is not
Yes, yes.
a issue. You see, but what happens is, will the High Court do an exercise which normally a court of original jurisdiction like a civil court should do,
Yes, my lord.
and give a finding of fact? You see, let us say that that's why I told you, let us assume that the party for which Mr. Ken Chaudhary is there, senior counsel,
Yes,
he's everything possible negative is against him,
Yes, my lord.
correct? We take it from you,
Yes, my lord.
even without going the documents, without even everything, any proof of your submission, we are accepting it for the time being,
Yes, my lord.
correct? Now, what do you propose us that we'll do?
One thing is that your lordship, kindly call the petition number, my lord.
It's okay, but what is the ultimate thing, ultimate prayer you are asking?
My lord, that thing is that, my lord, they never mention earlier petition also, my lord, in this petition, that an eviction operation is carried out by the government, my lord, to the order passed by the division bench, my lord.
Division bench, that's in a different context.
Yes, my lord. You also kindly go through the order, my lord. This land is.
My lord, the division bench never said
Yes,
evict
my lord.
somebody from the
Then
Patta land.
second thing is that, my lord. One thing is that, my lord. Second thing is that, my lord, that land which has been eviction has been carried out in the government land, my lord. So your lordship kindly go to the affidavit part, my lord. On the other hand, division bench has said we, my lord, take out the salary from the officers, my lord. How can they do, my lord? If your lordship has passed an interim order, earlier interim order has been passed, my lord. This is contrary to the order passed by the honorable division bench. If your lordship,
Mr. Chaudhary, this PL 78,
yes, my lord.
in which paragraph it says, what you call, you evict him without any due process of law?
Yes.
My
Where
lord,
does it say?
your lordship kindly go to, I go to the Poddut Bora judgment, my lord.
Yes, I'm having it.
Huh?
This is with me.
Yes, my lord.
Just indicate the paragraph.
Yes, my lord. I'm reading, my lord. How many one, my lord?
In English, we have a proverb called shadow boxing.
No, my lord. Actually, what happened? There, one after another, they file a petition, my lord. Earlier, they have filed a petition that was disposed of, and they are asking some document, this Purvanchal. Subsequently, another petition and file, my lord, and asking for cadastral name and other. That petition is pending, my lord. Meaning thereby they are doing delaying tactics to the eviction order. And that, my lord, affidavit has been filed by the, my lord, government, my lord. I am coming, my lord, one paragraph, my lord. My lord, I'm
Because
sorry
Mr.
to-
Chaudhary,
I'm sorry to
The,
interrupt, my
the,
lord.
the problem is, you know,
Yes,
the
sir.
problem is because my foundation is in the wrong place.
My lord, this
No,
foundation
schedule
is
A
so
B
bad.
land is of
Just a
130
moment.
biga,
Just a
and
moment.
my learned friend is talking about only 4
No, no,
biga.
just a moment. You see, why I'm saying is that foundation is wrong is that whenever you are making that statement, in my mind, I am only on order to rule 2,
CPC.
section 11, explanation 4. And then you see my, what you call, my views become restricted. Myopic, we say,
Yes.
it becomes myopic. You see,
Yes.
if you can demonstrate that the first repetition will, for the purpose of second repetition, the prayers made in the first repetition would constitute a res judicata for the second petition. Then I can understand.
Yes, sir.
But if there are separate reliefs sought for, and it is not interconnected and not what you call, it's a what do you say?
Within the
It's a
same part.
consequential relief, which makes a part of the same transaction.
Yes, sir.
Then it doesn't fall within the meaning of order to rule 2.
Yes, my lord.
And it may not be a case of constructive res judicata as explained under explanation 4 of section 11.
Yes, my lord.
So that is the difficulty. You will have to overcome that. Merely saying that there are 10 petitions would not be enough. You have to demonstrate that
Yes, my lord.
this is something which
Yes,
we
my
can.
In
See.
this case, my lord, 163 civil code has been barred by Assam Land and Revenue Regulation. 167, my lord.
Principle is always applicable.
Yes, my lord. That is,
Mm.
I know. But your lordship, I page 50, inner page 10, my lord.
You know why? I'll show you.
Of the Podut Bora, my lord. Let me.
I'll show you something. See page 62.
May I read, my lord, Podut Bora?
I'm showing you something. When you made that statement, civil procedure is bad, then I'm showing you something. 62, this is a form of Guwahati High Court, writ petition. After High Court of so and so, you see the jurisdiction, what does it say? What jurisdiction?
Revisional jurisdiction. my lord.
Right. So it is not extraordinary writ jurisdiction, as you all know.
Yes,
It is a revisional jurisdiction. So revision is very limited. If it's a revision, then you know the provisions. Revision can only be attributed either to a criminal revision under CRPC or a revision within the meaning of CPC. There can't be anything else.
Well, can we do one thing, well, this matter may be taken along with the division bench matter, my.
I will take it.
Your lordship.
Oh, then
your
you have
High
to,
lordship
then you
can
have
take.
to.
Can,
That
that shall be sent to the division bench, my
No,
lord.
no, why should I
The
send it?
subject matter is the same, my lord.
Why should I
no
send it?
subject matter is not same.
It
My
is-
learned
it is-
Pray before your lordship, man.
No, you can only pray before the division bench to
Yes.
call for the record of a second judge.
Yes, sir.
I can't say to a larger bench, please decide it.
Yes, sir. Today
So
we.
why to the division bench? Then I
Well-
can send it, if that power is available to me, I will send it to the Supreme Court,
My lord,
but I don't have that power.
my lord, one matter has been already been, my lord, division bench allowed, super lighting this thing. Where my lord senior. friend-
You have this, what you call, High Court rules with you. Just tell me where is that rule? That if a writ petitioner is same, all the cases could be clubbed and sent to the one court. Where is that rule?
Look, my learned friend is referring to a judgment as suo moto case which was taken up by the division bench of this honorable court. It was regarding, my lord, encroachment of the government land. That was in a different context altogether. This is a, my lord, cement factory where 130 because of patta lands are there, my lord. They are concerned with a small plot of land. That is why now they are bringing all these things, my lord.
No, they
Lordship
can-
will hear them. I am not saying don't hear them.
I am only one thing, my lord. There is a report from the circle officer, the 4 soil deed, which has been annexed here, my lord, on the basis of which my learned senior friend has said, this is a patta land, this is a forced document, my lord. I can produce all this document, my lord.
Oh, they are authorized to take, issue a certificate of forgery. I never knew that.
Yes, my lord.
Right.
Your lordship kindly go to the my lord report.
No, it's okay. Source of that power you show us first.
They have verified my lord record,
No, I
sub-register.
I understand.
Yes, my lord.
But they have a power to declare anything as forgery. That you'll have to show us. Who can declare
I
it a
shall
forgery?
take it through by the affidavit, my lord. This is the
No,
report.
no. Please try to understand my question. My question is, which law permits a lot mandal to give a certificate of forgery?
No, sub-register. Sub-register said. Sub-register said. That.
There is a way of placing documents in a court of law, my lord. Let them file an affidavit.
This type of document is not available, my lord. He verified the record, my sub-register,
It is not available is something else.
my lord.
To declare it a forgery is something else. That's what I was asking you. You are saying it is declared a forgery. That may
Yes,
not be
ma'am.
there.
That is not available on the record, ma'am.
That's okay.
Yes, ma'am.
It's okay, but that's not forgery. Forgery, you'll have to come to the civil
Yes,
court
ma'am.
or a criminal court and get it declared.
Yes, my lord. Yes, my lord. That is
That's
not
what I'm
available
saying.
on the record.
My lord, let us accept what my learned friend is saying is correct. Assuming, my lord, he says that out of the 130 bigger land, a particular plot of land belongs to them by forgery. That's a dispute to be decided. We are in a different plan. We are saying our factory's production has been halted unauthorizedly. That's the grievance. End of the day, my lord, the
I
civil court
come back to you,
decides.
Mr. Chaudhary. I just let Mr. Anil Chaudhary complete.
Yes, my lord.
Which paragraph in this Pradit Bordoloi?
Yes, my lord.
Pradit Bora. Which paragraph?
Yes, my lord. May I read, my lord? On going through the above as extracted provision affidavit by Joint Secretary to the concerned evidence. that-
Which para?
Earlier, my lord, I am saying the land, my lord, that particular land has been mentioned, my lord. Your
It's okay, we'll
lordship-
accept it. We'll accept it that your land is there.
Yes, my
Now,
lord.
where is that paragraph in Pradit Bora?
Yes, my lord.
Which paragraph?
I am reading, my lord, on going to the project
No,
indigenous.
you are reading somewhere, but I don't know where you are reading.
Yes.
Tell me where you are reading.
Interpage 10, my lord. Para 6.
And tell me page 10.
Yes, my lord. On going to the above external
Lordship's kind
portal,
permission. Can I take leave for 10 minutes?
it become evident that the state of Assam
Wait,
has
Just a
taken
moment,
public
Mr. Chaudhary. Otherwise also, I'll take it up in the second hour. Just currently hearing when this application comes.
People also so much so land has been prepared, approved cabinet on so and so his cycle and the senior council so and so so and so. Consequently, it has been decided inter alia chapter 10. Deputy commissioner required to almost care while according the permission transfer land protected bill. Deputy has been enjoined non-eligible person to get permission to acquire land within the protected build and block. Other elected land in paragraph 30 extracted, it has been a matter of fact. The difference direction code status report was called from the Deputy Governor District Tribal Built and Block. The little they furnished information regarding the various indicators G8H. The court appreciated the necessary accesses to identify illegal encroachment over the land has been carried out. The needful having done can direct the Deputy Commissioner to strictly implement the letter spirit of provision chapter 10. Consequently, the area illegal occupation of non-tribal otherwise nor hold the position evicted after following due process of the law. That is, we find the Deputy Commissioner Bongaigaon, Kamrup Metro Mogao. In such a way, thereby direct the Deputy Commissioner and the strict necessary action as required by the law against the enforcer for their personal affidavit verifying the action taken report. Then, your lordship, that land has been mentioned, my lord, in that order, my lord. Page 6, my lord, inner page. Serial number 5. Kamrup, South Kamrup Tribal Build and Block 2393 Bigha 0 Kotha, and that has been mentioned area of the government land so and so has been mentioned. That was evicted, my lord. And my lord, in that the total Tajia land 5523. Then amount of encroached by government land 421, 165 land that has been mentioned. Then nil. This is the land of person. The government encroachment so and so. My problem, my humble submission before your lordship is that, my lord. And the affidavit which I already did send, my lord. This one after another, they have filed a case, my lord. Earlier, the Purbanchal has filed a case, my lord. The court has specifically stated that in my interim petition stated that was not carried out, my lord. Although there is no interim order in second petition there, they said asking for a cadastral matter. Earlier asking for some different document that has been given. They also NICR just stress report and other all the document here. Cadastral man, it is not possible for the circle officer to give this report. Then, my lord, when it was carried out in the government land, they filed this petition, my lord. So this petition is interlinked, connected with the division bench matter. So your lordship has said we should mention before the division bench or all these things interconnected with this bench. Moment they pass an order, my lord, this order will be effective of the division bench matter because they said affidavit.
Now, can I record your statement as a responsible officer of the court?
Yes, madam.
Can I record your statement that Schedule A and Schedule B land are government land? Can I record that?
That has to be said by the government, my lord.
No. You are opposing the prayer
Yes, madam.
in respect of opening of the factory on Schedule A and Schedule B. Now, if you are objecting to it, you'll have to make a statement that this is a government land.
This is the tribal bell like that. That can be recorded.
No, we are not on tribal land. That's not a dispute raised here
Yes,
in
madam.
this petition. Whatever is the status of land is there. The question is whether the land is a government land, because now you are saying that it is a matter directly linked with the PIL,
Yes, madam.
where there is a direction to evict from a tribal land with due process of law, number
Yes, ma'am.
one,
Yes,
and number
ma'am.
two, from the government land.
My lord, government land as well as Pattal land also, my lord, that order. This is not only a government land.
Talent is with due process of law.
Yes, my lord.
If due
I
process of
am
law,
not that, my lord, of course, in the Pattal land, they have to issue notice. I am not on that. They are asking in the writ petition that government land which has been evicted, my lord, that shall be restored their possession on others, my lord. If that is so, my lord, then that will directly affect the order passed by the division.
then you are nobody to say anything because of the fact that if Mr. Handick is there to protect the interests of the government,
my
you are
lord.
not a spokesman for the
Actually,
government.
As a tribal man, I file a complaint petition before the, my lord, circle officer, my lord. First, my lord. On the basis of that, whole process has been carried out in this case, my lord. That is why I am the necessary party, my lord, in this case. Secondly, one thing is that they have produced some deed, my lord. Of course, this is my land, my lord. Civil court has been barred, and they put,
You have a copy of the writ petition? You have a copy of the writ petition?
yes, my lord.
Come to page 29, 28 and 29.
Yes, my lord.
Please read the prayer loudly so that I can also understand.
It is there will be admin call for the why the eviction back carried out by the respondent under the supervision of circular should not be adjusted as null and void, and why the respondent should null and void of the circle officer order should not be directed to remove bamboo fencing, put the entry point of the Schedule B land, and why the respondent should not prohibited from interfering in the running cement factory of the petitioner Schedule land, storing raw material for the manufactured cement over in the manner.
So
Or-
therefore, and last is pending, this will be reviewed, or Lordship will be pleased to stay for the eviction of the petitioners from A and B land along with structures and so and so. So you see, when the division bench says with due process of law,
Yes, ma'am.
it has to be due
That
process of
order
law.
is available, ma'am. Division bench order that is
So due
available.
process of law would be there.
Yes,
Now,
ma'am.
where is asking the
In
prayer,
respect of the, my lord,
where is the prayer that his government land should be restored to him?
my lord, that prayer is not available. my
It's
lord.
not there.
One thing is that, my lord, should not be, that circle officer Sonapur should not be executed null and void. Yes, eviction operation in government land, my lord.
Shows that that circle officer's order. Which page? Which page is that, Mr. Das?
Circle officer.
We are
order
not,
is-
in fact, we have done a statement to the defect that no.
They are not annexed in the
But-
circle
but
officer.
I'll give you the statement, Lordship. What has happened is that page 26, Lordship.
26.
Yeah.
What did you say?
That on 28/4, that is the day when it was
paragraph 53.
Please continue again. Please continue reading.
That on 28/4/23, Shri Amrit Singh, Vice President Commercial, had repeatedly requested the circle officer to give some reasonable time. Lordship, sorry.
No, it's okay. Please continue.
There is a specific, there is a specific paragraph we have made. Lordship, may you please to come to page 70, paragraph 33. May I? Page 17, paragraph 33. That on 28/4/23 at about 10:30 AM, the circle officer Sonapur Shri Gopal Sharma came to the factory premises of the petitioner along with 5 numbers of JCB, 1 proclaim, 5 numbers of dumpers, along with electricians of ACB in an ACB electric vehicle fitted with mounted ladder and 150 armed forces, and forcibly and illegally tried to enter the factory premises of the petitioners. And then Shri Amrit Singh, Vice President of the petitioner, requested the circle officer whether is there any notice under any provision of law for demolition of the factory premises and the ejection from the land of the petitioner. The said circle officer replied to Amrit Singh that there is no need to issue any notice for doing eviction from government land. And on this, Shri Amrit Singh informed the circle officer that the petitioner are not in possession of any government land, and the factory premises and its allied structures like fly ash shed.
No point reading paragraph 33. Because of statement being para 32. This you may omit reading. Page 32. No point reading para 33.
Because we have asked for the order.
It's okay. It's not a matter of your knowledge. Okay, so one point we are
So
accepting.
Lordship, one thing is correct, government said everything, my lord. Whether schedule A, schedule B land is the Patta land or the government land. In respect of my lord, government land, my lord, no notice is required, I think, my lord, as per.
But Patta land, well, that's.
As per government land, my lord, there is 18(2).
18(2) doesn't say no notice.
Only in respect of 18(3) notice is required. That has been mentioned. So 18 ejectment subject to the deputy commissioner eject any person from land over no acquired right, proprietor, landholder or settlement holder. When such person has entered into possession of government land, waste land, no person has acquired the right over the proprietor, landholder or settlement holder. Land has previously been reserved for the road or the roadside for the gazetting cattle order for the public purpose has entered into the possession of the from which they excluded the general and special order when the father no bona fide claim right to involve may be ejected or the vacant land forthwith. What has been used forthwith money. And the deputy commissioner may shall confiscate, destroy, crop, raise, or any building or any other construction erected without any authority of the land. See, a notice is required if it is a fast land line. Don't approve. Notice. TA notice is required, 15 days notice. 1-2 notice is not required.
Also, there is 150 bighas. So out of that,
Okay.
which
So that's
is,
all the pass orders when your application comes.
One thing is the government is available, my lord. You know, so
Yes.
that they are the main party by not to excel.
Yes, Mr. Bapujari.
Earlier, my learned senior friend was not appeared, my lord. It was filed by
It's
other
okay,
lawyer, my
it's
lord.
okay.
Subsequently, it was filed, my lord.
No, definitely,
Yes, my lord.
that is the beauty of having
I am reason behind it, my submission is something different, your lordship knows very well. That is why I given that document, sub-register, not register the document.
that is the beauty of having a senior lawyer.
Yeah, my lord.
He can work in any matter when he is instructed.
He also not appeared earlier.
No, whatever be. But the beauty of a senior lawyer is that only. That is why
Yes, my lord.
he's so coveted. He can work in any case and work out.
But I will be again traveling, my lord, with this. So,
What is that?
my lord, which is judgment of this honorable court passed recently, my lord, on 3rd of March 2023, in that, my lord, Silsaku eviction matters. Silsaku eviction matters. So, kindly present it here, my lord. This honorable court has taken into consideration all the applicable decisions as on today and the settled position of law with regard to eviction. And more particularly in respect of the provisions of Rule 18.
This, Mr. Das, just note, WPC 1156. WPC 1156 of 2023. Disposed of on 3/3/2023.
My lord.
I don't know the cost title, only the, except for the cost title.
A bunch of writ petition has been disposed of, my lord, by this common judgment. There, my lord will find, my lord, that Rule 18, virus of Rule 18 was also put to challenge before the division bench. The division bench has negated that, my lord, challenge.
For 18/1 and 18 and 18/1.
Everything is called out there, my lord. The coordinate bench has taken on board, my lord, all the decisions. There in Silsapo, my lord, only a public announcement was made that you have to vacate the land. No notice whatsoever was issued. And that action of the government, my lord, has been upheld by this honorable court. I think that in Rule 18/1, my lord, no notices. 18/2, no notice is required.
No, that argument would be valid for one, first part of the prayer. Challenging the decision of the what you call eviction.
Yes,
Correct. But here is the second aspect. There's an industry on Schedule A and Schedule B land.
my lord,
Government doesn't say it is their land.
my lord,
Rather, they have excluded that.
my lord.
Now, with regard to that, what objection you can have?
So if the land has already been settled, my lord, it will come again to revert back to the issue of settlement. If it has been settled, then, my lord, for ousting a person from a settled land, then again due process of law has to be.
It's true there. So you
Yes.
see, even if there is an inter-party dispute, let us say Mr. N.V. Chaudhary has a valid dispute. That is a dispute interstate between the parties. It has got nothing to do with the prayer made here.
Yes, it appears to be so.
Apparently so.
Yes,
Well, eviction is not carried on A and B, man, that's not my instruction, but government can say all these things, well.
No, it's not in private land is not been done.
Yes, well, eviction has been carried on the government land.
Only government land.
Because-
So we can exclude that.
yes,
In view of the coordinated bench judgment in this matter, we can exclude that.
Yes, well,
But what about the A and B land?
A and B, my lord, they will not say.
It's a private land. In private land, the government can't interfere unless it gives a notice and due process of law.
absolutely.
Lordship, the schedules are the pattas, everything is given. If the government land is, they will have certain, it cannot be in air worship. The if
Ah,
space.
yes, I have the printout. I have the printout.
My lord.
But I've seen this. By and large, it only says that 18
Yes.
and 18(1)
My lord.
does not require a notice, 18(2) would require a notice.
Yes,
And then it says it has approved of the what you call eviction right on water bodies because of the Water Bodies Act.
because of the water bodies,
Ah.
but precisely, my lord, the honorable court has dealt with that aspect of the matter. To what extent, my lord, government can exercise, my lord, its domain within the purview of, my lord, rule 18.
Correct, but 18 will not apply in a private patta land.
Yes, Lordship.
Definitely,
settled land.
That's the-
definitely. And that I have to. But if it is. Exercise to balance, no complaint. But.
Lordship, the last order may be Feroz, Justice Bhushan Kumar. A specific query was asked.
My lord, the intervener, my lord, who is represented by Leonard Senior College, if then, my lord, the intervener made, my lord, being an issue here, that, my lord, they are espousing the cause of the, my lord, particular tribal people. Now, if they say, my lord, that this is a tribal belt land, and this has been unauthorizedly, my lord, settled with them, then the issue would be defined.
Again,
No, then also you see, it's a issue which will only delay the process, but it will not affect the proceeding. You see, the reason is,
Yes.
you see, you change the role. My examples are very simple. You change the role, you become the lawyer of the petitioner.
My lord,
Correct. In your writ petition, can I grant Mr. the XYZ any relief?
absolutely not.
Correct. So in respect of a writ petition, we must know the contours on which we can travel. The court has to travel, number one.
Absolutely. So they will.
Second is, assuming that they approach the government, that this is that this is the tribal entity, this has been done, that has been done, then you will adjudicate, you exercise your right to do
Yes,
so.
Yes. Because 165 is clear. From chapter 10 is clear, my lordship is whenever I
That
did not.
petition is pending. That petition is pending. And there is an order passed by the honorable.
Mr. Jodi, I've told you, unless you show me that the connectivity that without prayer made in this writ petition, the earlier writ petition could not have been proceeded with. And it's an essential part of the prayer which ought to have been made in the first petition. Then I understand. Because if that is not there, we will only have to look into the what you call the proceedings here. He's only you see, you are arguing as if we are going for a disposal. His main issue here is an interim order, that once there is no eviction drive against A and B, and it is not a government land, they should be allowed to go inside it. They can't be restrained. The only issue boils down is that before doing so, you would ask the revenue to have a joint inspection done and identify and demarcate the land.
Yes,
And insofar as the government land is concerned, they will not enter.
absolutely.
And insofar as the private land is concerned, they will enter. And if the tribal subject proceedings are drawn up, it will be a different aspect altogether.
Absolutely.
There will be a separate information that we will be getting.
Complaint has been filed and that has been proceeding has been drawn out.
So
That is a separate
whatever orders we are, whatever orders we are passing will always be subservient to the principal relief. This won't have a permanent effect. I am not declaring a title,
Yes, Lordship, that's the point.
correct? So an order which has got no bearing with the title
No, sir.
Is-
After interim order, then one thing is that other petition may be called for, my lord. Who is
I am not calling for any record. You make a mention, you can have it before the division bench. But if it is necessary, you see. If I am required to that record for a proper adjudication of this case, then I can understand. But if that record is only for the purpose of placing some point, we are accepting whatever suspension you are making. You are not disputing anything. Neither the petitioner is disputing anything, nor we are saying that your submissions are incorrect. You are accepting whatever you say. I am going to the larger extent. I'll take it from you that he is the worst man on the earth. He has done all the mischiefs which he can. But still, whether he can be restrained from entering into that patar and whether it is a forged document or something, it's a proper court will adjudicate whether it's a forged, whether it is not applicable, whether you are going for an eviction. The second thing is, you see,
No, ma, I have
negative-
not said, my lord. I am saying that the government shall
No.
either file an affidavit. my lord.
no, no,
They
no.
are
What
confident
I'm trying to understand from
Yes,
you
ma'am.
is that you see, number one, let us assume that your land was there.
Yes.
Four plot of land covered by 4 seed deeds were your land, correct? Now, position this factory started when?
It was started by-
13.
2013.
Please,
The sale deeds are of 2003, 4. These are long.
It's okay.
term, so-
2013, let us say. So,
we made the complaint before the circle officer.
no, that is okay.
Because civil court is barman. I
That's
made the circle officer.
So therefore, you know, for a,
Whether that two cause of action can be minor club, definitely not. They have an independent cause of action.
so therefore you see, under the Limitation Act, the for declaration of a forgery, there's a limitation prescribed, and you say when you made a complaint in 2013, at least that factory started in 2013. Look, Mr. Chaudhary, those things are something which I am not traversing. Because if I make any observation, that will be damaging for the parties who are from whom we are representing. So therefore, those issues I will not touch upon. The prayer here is limited to an extent. So unless you can show that this prayer is not tenable, and therefore the interim relief also can't be granted, then we can understand. But supposing you raise that issue, and I am compelled to make an observation that will go against you completely.
I have to take instance of.
Because you see, I'll show you.
It is come my knowledge from recently, it is come to my knowledge.
No, that is okay,
Yes,
but let me show you something. '56.
Yes. 3 years punishment.
This is not a punishment, this is a limitation.
Limitation, my lord.
Limitation.
I-
56 says 3 years
Yes,
when
sir.
it comes to the notice.
Yes, sir.
Because if you
Period of limitation. yes, sir.
so if you compel me, then if I make an observation, that will go very strongly against you.
Yes, sir.
So we'll take it up at 2 o'clock when your application is there.
Yes, sir.
But this is what broadly which I'm, insofar as the government is concerned, we'll give them a direction that since there is a stoppage or preventive order not to enter, insofar as private land is concerned, within a time frame, they will demarcate. If it is 130 bigha land,
130 bigha land.
130 bigha land,
Lordship, there is also.
Mr. Handit, 130 bigha, just get an idea how much time they will take to demarcate.
No, Lordship, this point is it's here there is no specific order as to not entering. The barricade was put. Now, once they demolition, they went away. Now the question is that we had since the barricade is not there, we are not entering into it. But there is no specific order that you cannot enter also.
No, but still.
So that's why
You see, what you can do, you do it.
yeah,
But if it is, but if it is to be done by the order of the court,
that's
then I'll have clarity in my orders.
and
It will not
130
be there.
bigha is not barricaded.
No, whatever be there, but they will demarcate that land.
Yeah, the specific barricaded land, the specific barricaded land which is within.
No. You see, that interview, but I told Mr. Chaudhary at 2 o'clock.
Lordship, just I mean, can it be at 2:30? Because 2 o'clock, the special bench, where we have a matter. That'll take half an hour at the most. So 2:30.
Oh, okay.
Only
Because,
thing is that
because if I'm passing an order, I would like that my order would have clarity.
Yes, that
So-
would be.
So if your prayer is A and B, we'll have that A and B demarcated and given,
Given.
allowed.
Yes, sir. Only
It's-
that, my lord.
it will not be that in guise of A and B, you
Yes,
take
sir.
position of D and E also.
Lordship,
Yes, sir.
that is
Correct.
it. A and B, which you have mentioned.
But
Yes, sir.
130 bigha, Mr. Handy, you said there are two things. Number one, I don't know whether you are aware of not. Mandal is required to know that theolite, what you call, measuring, they are entitled to know it. And in the exams, it's one of their subjects, theolite. So 130 bigha, if they do the work correctly, can be completed within 4 or 5 days. 130 bigha. Because they'll have to put a stick and then try to measure it, and then they have their skill and it can be done.
We have
Correct.
the scale of measurement.
A small scale. Small scale. This big. This big.
They keep a parity, 1 meter is equal to, they take it, theoretically, they put it there, and practically when they make up the report, then they convert it. In the case of conversion of measurement. Yes.
So, so that 4 or 5 days, but still take instructions by 2 o'clock, 2:30, we'll take it up. Correct. How much time they will need to have that 130 bigha demarcated?
Because here what has happened, madam, they have exceeded their occupation over their land to the government. That is why, madam.
No, it's okay, because
Ultimately, madam, lordship will have to direct minor or demarcation. That will resolve the issue.
and Mr. Chaudhary, this is the second part when I'm passing the order. I'm just telling you because it will shorten the time. When I'm passing the order, I'll make it clear that insofar as the private rights are concerned, that can be always agitated. This order will not create a prejudice to
Yes,
them.
sir. Understand. Yes, sir.
What is it? At 2:30, we'll take it up.
Yes, sir.
Okay.
Oh, bless.
I'll take a break and come back.
This matter taken at 2:30.
At 2:30. Since I excuse Mr.
Yes, sir.
Chaudhary.
Correct, ma'am.
Yes, sir. Maintained in State Bank of India, Dhubri branch, by retaining an amount of rupees 4,35,000 till disposal of the connected rate petition. Next, Madam. In view of the projection that the salary of the petitioner is routed through the said account, upon instructions, the learned counsel for the respondent numbers 3 to 6 has submitted that if they are permitted to keep a lien on rupees 4,35,000 and retain it till the disposal of the rate petition, they would not object to the prayer made in this rate petition. Next, accordingly, the prayer stands allowed by providing that the State Bank of India Dhubri branch will be permitted to retain a sum of rupees 4,35,000 in account number, so the same account number of the petition of the applicant, namely Dilbar Ali Ahmed, DILBER Ali Ahmed, AHMED. And allow operation of the said bank account for any other transactions. Next paragraph. The applicant is permitted to produce a certified copy of this order to the before the manager.
Chief Manager,
We have already withdrawn the whole.
Chief Manager.
We have already withdrawn
Oh,
the
yes,
whole.
yes, next, at this stage, the learned counsel for the respondent number, opposite parties numbers 3 to 6 has submitted that that as per his instructions, the State Bank of India, Dhubri branch has already withdrawn the hold
Whole by keeping rupees 4,35,000.
by keeping rupees 4,35,000 to be retained in the account. Full stop. Next paragraph. In view of the is intellect the application stands allowed to the extent as indicated above. Full stop. In the event the petitioner finds any difficulties in operating the account, he may produce a certified copy of this order before the branch manager, SBI Dhubri branch. Correct? Now, what order is there in the
Pleading is
petition?
completed.
It can be heard.
It can be had.
You want to take us the, you want us to take up the hearing today? Then after the finishing of the board, we'll take it up.
Today itself.
Today I am having some problem. One matter
Okay.
is in state commission. One matter is there in state commission. I have to get it.
Oh, acha. In the petition say, case is ready as regards service and pleadings are also concluded. Let's the matter for hearing on, give a date for hearing.
Maybe on admission, my lord. Yeah.
We will hear it if it comes, because if I take up every matter in admission, then there can't be a hearing.
My lord,
Hearing.
This fixed for
on
hearing, my lord, it-
12/6. Okay.
12/6.
Much.
God bless.
6.
God bless.
Yes.
It's a content petition, my lord. Order passed in WPC 1010/2020.
Okay. Content. What is your name?
Meet Alonso.
D. Talukdar for the petitioner. Non-compliance of order is so and so. Contempt petition. Notice starts within 2 days. Returnable on so and so.
4 weeks.
The pendency of this contempt petition shall not be a bar for the respondent to comply with the order. Take steps.
Item number 9 and 10, stay matters.
Lordship, my senior is on next. My senior is on next. Kindly pass over the matter for timing.
For timing, okay.
Artin.
Yes, Mr. Fukan.
In this case, and
Who's appearing for,
non-corporation is the Bhandar is appearing.
this is IOCL.
Not said.
Just give a scroll, SC IOCL. Mr. Handy, why you're not giving that no objection certificate? You see, it's a retail outlet. You were required to give a NOC. Since you did not give NOC, the IOCL has withdrawn their letter of intent.
Lordship, one paragraph was sent, However, the circle of the could not be provided a report given a consent for discrepancy among the co-partner. Well, that report has said that there is a discrepancy among the co-partner of the, as the boundary of the that minor NOCs, those whose mallet he was mallet asked to mallet the same.
Show me that.
Lordship. Paragraph 8, Lordship. There are some discrepancy amongst them are co-partner. That's why mallet the NOC cannot be given.
Now, what is the discrepancies? I don't know. You'll have to spell it out.
Lordship, that is not clear in the mallet that in the paragraph.
Then it was the circle officer to be here. If he gives you reports like this, we'll call him here with records.
Lordship, give me some mallet that I can obtain another instruction. Why mallet it?
No, because you see, he has lost his retail outlet. We'll give you a week's time. If they don't send you the documents, then we'll call for this person.
Sure.
Mr. R. Fukun, then a counsel for the petitioner. None appears on call for the Indian Oil Corporation Limited. I responded numbers 1, 2, and 3. Full stop. Mr. J. Andy Leonard, counsel, standing counsel for respondent numbers 4 and 5, has submitted that he has received a paravise comments, wherein it is mentioned that the circle officer, Golaghat Revenue Circle, could not provide report giving consent for issuing NOC because of discrepancies among the co-pattadar as to the boundary of the plot of land. Full stop. The court expresses its displeasure with the paravise comments given by the circle officer Golaghat Revenue Circle, Golaghat, because in his paravise comments, he does not describe the nature of inverted commas discrepancies among the co-pattadar. There's discrepancy inverted comma closed among the co-pattadars as to the boundary of the plot of land. First of all, it is also not mentioned how many pattadars are there in that in the concerned land. Because in the where is your LOI?
So I got it, annexure to page 46.
Page
46.
46. This is your LOI.
Not so.
Because in the LOI dated 6/11/2019, the land offered by the petitioner is at measuring 6 to 5 square meter approximately.
And it's not for subsequent LOI, Lordship. I'm sorry, Lordship.
That's why I asked you,
Page 52, Lordship.
page
Page 52.
52.
Also an extra for.
Okay, then LOI is dated 29/10/2020. Wherein it has been mentioned that the petitioner has offered, petitioner namely, give the name also. Namely Rajiv Gogoi, RAGIB, GOGOI, Gogoi, had offered a plot of land at measuring 625 square meter approximately with 25-meter frontage and 25-meter depth, DPTH depth, at survey number oblique dark number 159, patta number 94, village Sakaradhara, SAKARA, Gaon, Taluka oblique Moza, Atgaon, in the district of Golaghat. And subsequently, the petitioner had offered land measuring 675 square meter approximately with 75-meter frontage and 25-meter depth of dark number 1460, patta number 372 of village Chakora, CHAKORDHORA, Gaon, Moza Atgaon, district Golaghat, owned by him. Full stop. Next, therefore, comma, from the parawise comments, nothing can be culled out. Full stop. The circle officer is a sufficiently senior officer in the Golaghat Revenue Circle. And therefore, he is put to notice that the court has not appreciated a parawise comments containing no details at all. The court is inclined to give 7 days time from today to the circle officer, Golaghat Revenue Circle, Golaghat, to give better particulars regarding the land for which he is giving a report, comma, the name of patta holders who have raised objection, and thirdly, why the boundary of the plot of land could not be ascertained. Full stop. Anything short of such disclosure would compel the court to pass appropriate orders on the next date, requiring personal appearance of the circle officer on a date to be fixed. Full stop. Then we'll just add one more line there, as well as documents which prevented issuance of NOC. Then anything short of it will influence. Next paragraph. The learned standing counsel for the Revenue Department is requested to transmit a downloaded copy of this order to the circle officer, Golaghat Revenue Circle, to the additional deputy commissioner within bracket administration, bracket close Golaghat, who had forwarded the circle officer's report, parawise comments of the circle officer to the learned government advocate. Next paragraph. This, the. The court is also inclined to put the district administration of Kolhagar district to notice that in view of the non-issuance of no objection certificate to the petitioner, comma, his, the letter of intent in his favor by the Indian Oil Corporation Limited, comma, Assam Oil Division has been recalled. Therefore, the district administration shall also inform the court as to why within a reasonable time the petitioner was not communicated the inability of district administration to issue a no objection certificate, comma, which has compelled the petitioner to approach this court. After this, that paragraph, that anything short of that will entail. But those two paragraphs will be together.
Interim order may be continued, Lordship.
Oh, okay, interim order passed against stands extended to the resident of Western. This term, they're giving you 7 days. 7/6/2020. This one 7/6/2023. 7/6. You are there?
I'm for the IOC, madam. Sorry.
Acha, Mr. P. Bharadwaj for IOC. 1 and 2.
1, 2, and 3.
3 also. Okay, 1, 2, and 3. So you will be for
I'm for the deputy commissioner and circle officer.
4 and 5.
4 and 5.
Yes,
Okay,
1, 2, and 3.
4 and 5, Lord.
okay. Mr. Hindik will be for 4 and 5 only.
Obliged.
We have directed them to produce the relevant particulars.
That will be this.
Lordship, may I get the order copy, Malad, today, Malad, I can be communicated to the,
You want physical copy? We'll do it. Okay, we'll give it.
Malad, that 7 days time, Lordship, after, that's why, Malad, it will be communicated.
I'll try to give it.
Lordship, obliged.
Item number 7 for hearing.
May I please, your lordship?
Yes.
But this is a case, I've been compelled to approach this honorable court, my lord, before, because before approaching this court, I tried my best, my lord, to persuade the respondents to give
APDCL, SC APDCL. Just wait for some time that the APDCL come.
my lord.
APDCL council.
He was there, my lord.
Just wait for 15 minutes.
Mr. Sharma is here. My lord.
Oh, you are there?
I'll be there for application for the connected matter, just see who's there. For the connected matter, also I'll just check out who is there.
Okay, okay.
Sorry, my lord.
He's trying to get the council.
My lord.
Just wait for some few minutes.
My lord.
Wait for
My
2
lord.
minutes.
In spite of all the difficulties in Manipur, my lord, have come because for the last 3 years, I'm suffering, my lord, because.
No, but what I understand is now they are saying that once it is disconnected,
My lord.
we have to make a fresh application. What is the difficulty in that?
It's not so, my lord. Their disconnection is totally illegal, my lord. Illegal for the reasons that they have not followed the procedure laid down in the Act and regulation itself. So I'm not supposed to apply for fresh connection, my lord. It is not required because the law is very settled that, my lord, once bill is cleared, it has to be reconnected. But here in this case, it's not question of clearing the bills. It's question of whether the disconnection was illegal or not, my lord. As per their own regulation, it is illegal, my lord. And their affidavit also says so, my lord. They made it a prestige issue, my lord. I did everything possible to persuade them, my lord. I paid the dues which were not validly demanded. Then I paid the reconnection charge also. Then they did not do it. Then I even served a notice saying that please do it, otherwise I'll have to go approach the court, and which will include compensation and damages. Then also they did not. Then I sent one of my juniors, my lord, from Guwahati to persuade them They said nothing doing, we have removed the meter, so therefore you have to apply a phase connection. I did everything possible, my lord, to avoid litigation. I have been compelled to do that, my lord. And
Yes.
because the disconnection is totally illegal, my lord. My lord, may I take your lordship to the 11th portion, my
No,
lord?
let them respond. We will come back to you. Yes.
I will
Mr. Sharma.
breath, my
Take your breath. Take your breath. Take a seat. Take rest for 2 minutes.
My lord, the case of the petitioner is that we did not serve him notice under section 56(1) before disconnection. My lord, APDCL generates two type of bills. The bill which he has annexed in the writ petition, that is PDC, permanent disconnection. Before that, my lord, we issue them normal bills, and in our bill, it's specifically written that under section 56(1), my lord may look into my affidavit. Page 27.
Take your breath. Take your breath. Don't rush. Yes.
Yes. So my lord may say disconnection notice.
Yes.
Under section 56(1) of the IE Act 2003, power supply to a payment will be disconnected anytime due to the non-payment of area amount ignored if already paid. Thereafter, my lord, again in the next month thereafter, we send him the same notice, a new bill, and there was an area that was included in it that under section 56(1) of the IE Act, power supply to your premises will be disconnected anytime due to non-payment of area amount if ignored already paid. Thereafter, simultaneously, same thing we did for the next months. Then, my lord, when he did not pay, we issued him a intimation for temporary disconnection of the electric supply.
Where is that?
That is at Annexure 16, Annexure 2, page 16, my lord. Page 35, running page 35.
Yes.
This is to inform you that your supply has been temporarily disconnected with effect from 20th August 2020 due to following reasons: non-payment. You are requested to remove the cause of disconnection and intimate this office at the earliest. You are also requested to pay a sum of 13,706 towards disconnection and reconnection charges. If the cause of disconnection is not removed, the satisfaction of this office and amount is not paid, within 45 days of this notice, your supply will be disconnected permanently without any further notice. So this was the notice as per the regulation after complying with section 56. My lord, if my lord pleases, may I just, my lord, first refer to the act once. Section 56.
Because you see, even in connection with this disconnection notices,
Yes, ma'am.
there is an admission at paragraph 6 of your affidavit that the disconnection was made before the date of payment.
No, thereafter, the respondent authority issued the permanent disconnection. My paragraph 6, my lord. That as the petitioner failed to pay electricity dues May 2020 before the last date of payment, and therefore the electricity connection was temporarily disconnected. This is a temporary disconnection, my lord, not permanent disconnection. Now his electricity connection has been permanently disconnected. Paragraph 6. That was section 56, my lord.
Yes.
Page 34 will be the
Yes.
where any person neglects to pay any charge for electricity or any sum other than a charge for electricity due from him to a licensee or the generating company in respect of supply, transmission, or distribution, or wheeling the electricity to him, the licensee or the generating company may, after giving not less than 15 clear days notice in writing to such person and without prejudice to his rights, to recover such charge or other sum by suit, cut off the supply of electricity, and for that purpose, cut or disconnect any electricity line or other works being the property of such licensee or generating company through which electricity may have been supplied. Transmitter distributor will and may disconnect supply until such charge or other sum together with any expense incurred by him in cutting off reconnecting supply are paid but not longer. Provided the supply of electricity shall not be cut off if such upon deposits under protest an amount equal to some claimed from him, the electricity charges due from him each month calculated on the basis of average charge of electricity paid by him during the preceding 6 months. Whichever is less, pending disposal of any dispute between him and licensee. With this regard, my lord, section 56, the Supreme Court have elaborated the entire section. My lord, I have taken a judgment to it. At page,
Give the suggestion for Mr. Sahu.
I have, this is not, even though it's reportable, it's written, it has not been reported in the SEC. I have a dispute copy. May I read, my lord?
Which paragraph?
Paragraph 3.3, page 6, my lord.
This is how this is 2024 SEC 650.
20.
My lord, may I also note it?
For SEC 650,
2024 SEC 650.
yes, I've got it, madam. I have also, this is in my favor, in fact.
Yes, my lord. 3.3, my lord. Madam, I'll just read from the starting at page 3.5. It was further submitted.
Page?
5.
Yes.
It was further submitted when a bill or demand is raised, which is disputed by the consumer, he may raise the dispute before the authority as provided by section 42 subclause 5, sub 42 subclause 6 of the Act, or avail such remedies as may be available in law, such as a suit of declaration and injunction, consumer dispute before the consumer forum, arbitration if provided by the governing agreement. In this case, he has not applied under the consumer forum, which he should have been. Section 561 of the Act confers the power of disconnection of electricity supply for default of payment upon the licensee and provide the conditions when such a power may be invoked. The procedure and the manner of exercise of such power, the period of which such power can remain effective, and the circumstances under which power cannot be exercised. Subsection 2 of section 56 says, bars the remedy of disconnection of supply for default of payment if the consumer deposits the amount dependent under protest, or the demandant has raised 2 years after the sum became first due, albeit the same had been continually shown to be recoverable as area of charges. Now, my lord, the payment which he has made, that was not under the ambit of 56(1). That was under the ambit of clause 8 of 8.2. Permanent disconnection. And .3 at the bottom, I know. This is where he has paid the charges, and that is why his bill was PDC, the format 20. So, my lord, the restoration, what he had got an interim order in his favor, where the Honorable Court, after hearing the matter, said that you apply for fresh connection. And we also agreed that we will give you the connection. But we cannot give you the same consumer number and the same meter bill number, because that we have already taken as a PDC, permanent disconnection. And the availment of the temporary connection, my lord, if may see before 8.3, there is temporary connection. And permanent disconnection does not have the facility of giving or restoring the connection which has been already permanently disconnected. That is the ERC supply code. So as of the department, my hands are tied. Thereafter, he brought the argument that my notice under section 56(1) was not been given. Supreme Court in the judgment, which I am relying have stated that 15 days notice has to be in the bill itself. For that, I have got another judgment. I'll show you. My bill, which I have raised to him during the 2020, it has been specifically said that 15 days within you have to pay the bill. He never paid the bill. After that, we gave him an intimation that we were going to go temporarily disconnect your electricity supply. He did not pay. Once we issued him the permanent disconnection, then he paid. And my lord, the bill which he refers to, my lord may see there is RC/DC. RC means reconnection and DC means disconnection. So his bill was propagated in a disconnection under 8.3, which says, my lord, the clause itself, the format 20. My lord, I'll just, if my lord permits, may I read the 8.3 once, my lord? 99 page. The supply shall be disconnected permanently in the following cases. On the termination of the agreement, if the cause of which the supply was temporarily disconnected is not removed within the notice period, provided that if the service of the consumer remains continuously disconnected for 180 days, not being a temporary disconnection upon request of the consumer, the agreement shall deem to be terminated on the expiry of 15 days or after expiry of initial period of agreement, whichever is later, without prejudice to the right of licensee or the consumer under the Act for recovery of any amount due under the agreement. After termination of all the agreement, the licensee shall intimate the consumer in the format 20 of this code. So we absolutely did this. So now, my lord, may just go to page 97 once. That's a chapter of AERC supply code with regard to our disconnection and reconnection. My lord may see disconnection. The disconnections are of two types. One is 8.2, that is temporary disconnection. Then there is 8.2.1, disconnection due to non-payment of bill amount, disconnection on other reasons, reconnection and restoration of power supply. That is only limited to temporary disconnection. My learned senior friend here is stating here that you should give me reconnection restoration as per 8.2.3. Me as an authority of an APDCL, we don't have that power. Once we have disconnected you under PDC. And now the my lord before you has to be whether is the regard that whether the permanent disconnection that we have done, whether it was per law, whether we have violated anything. And therefore, my lord, I have saying that section 56(1) is with regard to the notice, which my friend says that we have not given you a notice. For that, my lord, I would like to refer one more judgment, 2021 SEC online SC 870. So
It's okay, Mr. Sharma.
Yes.
Because I thought by asking you this question, it will be shortened, but then I'll hear Mr. Sahu first.
Yes, ma'am.
Because it will be appropriate that
Yes,
he
yes,
will operate. The preliminary point you have raised.
Yes.
Now, hear Mr. Sahu.
My lord, first of all, I'm sorry to say that my friend has given wrong information to this honorable court that there is an interim order. What he is referring is of the order dated 21/4/2022. 21/4/2022, my lord. Hello, sir, kindly see 21/4/2022. This is the note sheet, my lord. Last sentence, my lord. Pendency of this writ petition shall not be a bar for the respondents in the APGL to restore the electricity connection in the premises of the petitioner. And then, my lord, it is I was never directed to apply a phrase. The court never said that I should apply a phrase. And then And then order dated, my lord, 27/4/22. 27/4/22. In the event of any such a petitioner shall serve requisite extra copies of this petition so and so tomorrow. In the event of any such application filed by the petitioner for fresh electricity connection, after such disconnection, electricity is premises so and so, the respondent shall forthwith give necessary supply of electricity. I was given liberty to submit application for fresh connection. And my case is not for fresh connection, so therefore I did not, my lord. It was liberty, never a direction. Then my case is that, my lord, your lordship may take from their own affidavit. Your lordship may kindly see their affidavit, my lord. Their own affidavit is in my favor. Page number 23, my lord. Running page 4 of the affidavit. Their affidavit, my lord. Am I right, my lord? Page number 23. Their affidavit running page 4. First, we'll have to clarify this
Just a moment,
temporary part, my lord.
just a moment.
Yes. First, we have to clarify the temporary connection, then only permanent connection will come. If temporary connection is illegal, then permanent connection is bound to be illegal. Because a mistake at the initial stage cannot be corrected subsequently. There is a settled law.
Para 4.
My lord, page number 4, my lord, page number 4.
Page 4, yes,
My lord, it is pertinent, my lord.
yes.
It is pertinent to mention herein that the temporary connection of the petitioner premises was done on as per 8.2.1 of the AERC 2017, wherein it is clearly stated that 15 days notice is to be given before temporary disconnection. In the instant case, the notices issued to the petitioner were duly served as the electricity bill is said it should contain the notice under so and so Electricity Act. Therefore, that 15 days as per 8.2.1 of the ARC was duly complied. Now let us, they are relying on the notice which is in the electricity bill, annexure A1, annexure A1, series A1, which my friend read out sometime back. The disconnection notice. First of all, this disconnection notice cannot be said to be a disconnection notice because they have to give a notice, separate notices to be served, my lord, as per section 171 of the Electricity Act. I'll come to that point. Now, but otherwise also this is not the disconnection notice in this respect, because my lord, they are saying that disconnection was done as per 8.2.1 of the AERC, their regulations, my lord, 2017. But here disconnection notice says under section 56(1) of the Indian Electricity Act 2003, power supply to your premises will be disconnected at any time due to non-payment of arrears amount if you not already paid. So this is disconnection notice, even if it is assumed to be correct, though it is not, is under section 56(1) of the Indian Electricity Act. Whereas the disconnection has been done as per their own affidavit, as per 8.2.1 of the AERC 2021. I've given reply to this, and my lord, I have quoted the relevant portion under which it has been disconnected as per their own affidavit, not my submission, their own affidavit. Page number 42, my lord, running page 5 of my reply, rejoinder, which my friend also read out sometime later. Page 42, am I right, my lord? My page number rightly, I don't know whether it is page 42, my lord.
Page 42, yes.
My lord, running page 5, my lord, is it? My lord, that in reply to contest number 5 of the affidavit, the petitioner begs to submit that the so-called notice served through electricity bill is illegal and not valid in the eyes of law for the following reasons. In the advertisement made in the respondent in the said para number 5, it has been repeatedly stated therein that notice under section 57(1) is served along with the bill. Whereas the respondent themselves have stated in said paragraph that temporary disconnection was done on 28/2020 during peak COVID-19 period under Rule 821 of the AERC 2017. The said provision is reproduced herein below for ready reference. Temporary disconnection. 8.2. The supply may be disconnected temporarily in following cases. Disconnection due to non-payment of bill amount, where a person neglects to pay any charge for electricity or any other dues, some due from time to licensee by the due date mentioned in the bill in respect of supply, transmission or distribution or wheeling of electricity to him in the licensee may be after giving not less than 15 days, clear days notice in writing to such person. clear notice, my lord, has to be given in writing, separate notice, my lord. Even otherwise, the notice contained in the bill doesn't say anything about this regulation which they are referring to. My lord, as far as the payment of the bill is concerned and saying that I have paid, so therefore you connect it, now doesn't survive. Because, my lord, now I'm on the illegality of the disconnection, legality or illegality. I wanted to avoid litigation. I wanted to sort out the matter amicably by under any circumstances by paying the dues which were not due, not payable. Now that doesn't survive at all. Now it is whether to be decided. It is to be decided whether the disconnection is valid or not. That is to be decided. Once not valid, then I'm entitled to all the subsequent benefits. And if valid, then I have no case, my lord. I have no case. Now, my lord, your lordship may kindly see, first of all, they are saying that disconnection notice is contained in the bill. So therefore, they did not serve any notice. The notice which is contained in the bill is regarding 56(1) of the Indian Electricity Act, whereas their disconnection is under their own regulations, which I have reproduced. So it doesn't tally, my lord, this cannot be taken into account. And now 56(1), my lord, of Electricity Act, and it also is contradictory to their own statement because they have themselves saying that they have issued notice separately, page number 35, my lord, of their affidavit. Now they have
Just a
themselves,
moment.
page 35, my lord.
Just. Yes.
My lord, they are themselves saying in their affidavit at one point of time that the disconnection notice contained in the electricity bill itself is sufficient notice, whereas they themselves in page number 35 had issued a separate notice purportedly which they have never served. I'll prove how they have not served. Then if it was already, if the notice in the bill is to be taken as a valid notice, then what provoked them? What was the necessity for them to issue this separate notice? If at all they have issued, which they have not issued, but I'll come to that point. Page number 35, they are saying that they have issued the notice separately to me, which I never received. Which was never served. It is an afterthought after filing of my writ petition. Page number 35 itself, they say that they have issued a separate notice. If it was necessary, then why, if it was not necessary, as per their own submission, it was not necessary because the bill itself contains the disconnection notice. So why they did it? If at all they did it, which they did not do. Now I come to the section 100.
This is how the first line itself makes it clear.
My lord.
Of page 35.
My lord.
First line itself makes it clear.
Sure.
First line of
My lord.
page 35.
Intimation consumer after temporary disconnection.
After.
Yes.
So not
yes,
before.
Now I'm saying, my lord, that this notice is a concocted, fabricated one because, my lord, page number 171 of the Indian Electricity Act. The Electricity Act may kindly say, my lord, how notice to be served. Section 171. If it is not followed, then there is no notice at all in the eyes of law. Service of notices, orders, or documents. Service of notices, orders, or documents. My lord. Every notice, order, or documents by or under this act required or authorized to be addressed to any person may be served on him by delivering the same after obtaining signed acknowledgement receipt thereof or by registered post or such means of delivery as may be prescribed. where the appropriate authority is the addressee at the office of such officer of appropriate government may prescribe in this behalf, where the appropriate commission is the addressee at the office, where a company is the so and so, where any other person is addressee at the usual or last known place of abode of business of the person. My lord, they have never served it. They've never served it because I have been receiving the bills, but never a notice, my lord. They can prove how they have, whether they have done it. Then, my lord, next, my lord. Every notice, order, or document by or under this act required or authorized to be addressed to the owner or occupier of any premises shall be deemed to be properly addressed if addressed by the description of the owner or occupier of the premises, naming the premises. My lord. It was never even inserted into the door of the premises, my lord. Then it may be served by the delivering it or a true copy thereof to some person on the premises. There is a caretaker in the building. It is an Orient Place, my lord. There are about 60-70 offices units. Caretaker is there, and to whom they have been serving the bills. Then, or if there is no person on the premises to whom the same can be responsibly diligent or delivered, by affixing it on some conspicuous part of the premises. They have never followed any of the procedure, my lord. They have not fixed it. Whether they have fixed it, they have to take a photograph and show it to us that they have fixed it, which they have never denied after my filing of my rejoinder also, my lord. So, my lord, my case is, it's very simple case, my lord. It is not at all a complicated case. My case is, my lord, that, my lord, the temporary disconnection is in violation of their own regulations. Their own regulation provides 15 days notice. They say the notice contained in the electricity bill is sufficient, and that is for 56 Electricity Act, not under the regulations. So therefore, the temporary disconnection itself is illegal. So therefore, all subsequent developments cannot be validated under any circumstances, because what is wrong in the initial stage cannot be corrected at the subsequent stage, my lord. Then secondly, my lord, this notice which they are saying for the permanent disconnection is never been served, never been issued. It was an afterthought after we filed the writ petition. Your lordship will kindly see the order that was passed. This petition was heard on various occasions by various benches, my lord. Various benches. Your lordship will kindly see page order dated 29/22. 29/22. It was by his lordship, my lord, Justice Sumant Syam. Pleadings are also complete in this case. Since the exponents are already presented, no formal notice required. Pleadings are also complete in this case. As such, let matter be listed again on 3/11/22 for final hearing as fixed item. 3/11/22 for final hearing. It was already heard. Then, my lord, your lordship may kindly see the order dated 3/11/22. 3/11/22. Mr. S.P. Sharma, Learners Counsel for APDC, prays for an adjournment to produce the records of the case in original, which may contain the decision and the reasons thereof as to why the electricity connection of the petitioner was disconnected. Listed on so and so, which they never produced, my lord. Therefore, it could not be disposed of. This case was listed for final disposal on 4 or 5 occasions, my lord. And I had to come from Manipur all throughout on this case, my lord. And now, my lord, my very simple case. Now I'm not on that I have paid the bill, so therefore they should restore it. They should have restored it. Now it is not, because I did it because I tried to avoid litigation under any circumstances. I did everything possible. I even sent my juniors from there, Guwahati, Usha Das. She went and persuaded them. They said nothing doing. They are saying that, my lord, they have removed the meter, so therefore they cannot be a reconnection. Now, my lord, the last date of the bill itself says, your lordship, kindly see the last date of the bill, my lord, which they have also last day of the bill, page number 14 of the writ petition, my lord. Bill amount, page number 14, my lord. Bill amount so and so, due date 29 March 22. Now I paid it on that same day. Your lordship, kindly see next page 29/3/22. It was paid. Now how could they say that they have removed the meter, etc., and before the last date? And even if they removed, it is their fault, and they cannot take advantage of their own fault. This is quite settled by the Honorable Supreme Court, my lord. I've given the list of the cases, my lord. Once cannot take advantage of their own mistake. My lord, this is, I have given the list, my lord. 2012 9 SCC 310. 2012 9 SCC 310. Page number, para number 28. Very simple para, my lord. I'll read only one paragraph. Two 9 SCC 310.
Yes,
My lord, para number 28, my lord. A person alleging his own infamy cannot be heard at any forum. What to talk of a writ court? As explained by the legal maxim alleges from, I can't read it out. If a party has committed a wrong, he cannot be permitted to take the benefit of his own wrong. So it's various judgments, my lord. So now they are saying that they have removed the meter, so therefore they cannot reconnect it. Now they have removed the meter before the due date, and they are trying to take advantage of these mistakes. So, well, this is very simple. Well, this is the only case. My case is that the disconnection is totally illegal, and no order has been issued. This honorable court directed them to produce the order, saying that this court's order, my lord, is very clear. Order dated, my lord, order dated 3/11/22, asking them to produce the reports wherein the disconnection order, regions, etc., is available, which they never produced. Even they have not issued any formal disconnection order. They have only disconnected it without any order. This honorable court wanted to see what is the order of disconnection, which they never issued. They have never produced. So therefore, it was just a this was an arbitrary action, my lord, of the authorities. I don't know, knowingly or unknowingly. Because I think, my lord, this has never been agitated by any person. They are suffering, because I thought of bringing it before your lordships, because this is committing. Many people have been suffering, my lord, for reconnection 30,000, something like that. There's no material. But what prompted me, my lord, to file this case is that I persuaded them. I tried my best to persuade them. I even paid the money which was not liable to be paid. I served legal notice. I sent my juniors and to persuade them. So I thought that it should be brought to the knowledge of the case once for all. Now, my lord, now that the notice itself, as per their own submission, as per their own affidavit, my lord, it is saying that it was done as per their own regulations, which is not at all. They are saying that. So therefore, my lord, the disconnection, temporary as well as the permanent, is not legal, my lord. It was totally illegal and malefied exercise of power. So therefore, my lord, they deserve to be taught a lesson, my lord, once for all, and I'm entitled to the rent, the damages that caused to me, my lord, because, your lordship, I was getting 30,000 rupees rent per month. I've annexed the agreement, my lord, rent agreement. After, my lord, after the establishment of the permanent high court, my lord, I stopped practicing here, my lord, regularly, and I shifted my practice to Manipur, my lord. Before that, your lordship is quite aware, I practiced for about 25 years, my lord, 25 years. So I had the office, I had a paid everything here in Guwahati. So I rented out after I shifted my practice at Manipur, my lord. So therefore, I have incurred a heavy loss of about, my lord, for the last 3 years after their temporary disconnection, which I'm liable to be compensated, apart from damages. Your lordship, one more thing, my lord, your lordship, kindly see that the manner, my lord, in which they have acted all throughout, my lord. I even requested them, even after filing the case, nothing, they said nothing doing. They just said that I have to file an application, fresh application for fresh connection, reconnection, which is not at all, my lord, enabled. And I don't think it has such things can be encouraged, my lord. So.
yes, Mr. Sharma.
My lord, first of all, my lord, I would like to take to my lord Indian Real Estate Act once. Again, I would like to take to the act.
Yes.
Section 50, man.
15.
50. The state shall, may I read my page 31. The state commission shall specify in electricity supply code to provide for recovery of electricity charges, intervals, meters by generating company or licensee at such stage of generation, transmission, or distribution, trading of electricity, and as such, for intervals for billing of electricity charges, disconnection of supply of electricity for non-payment thereof, restoration of supply of electricity, measures of preventing. Under this code, we have formed the AERC, my lord. The book.
Yes.
Yes. So under section 50, the state has the provision of making AERC. So my lord, the book I have already shared with you. In a notification, my lord, it is there that in the exercise of the power conferred under section 50, the first page. Notification. Gadget notification. In the exercise of power under section 50, clause 10 of subsection 2 of section 181 Electricity Act, and all other provision enabling in this behalf, and after previous publication, Assam State Electricity hereby makes the following regulation to replace the electricity supply code and related matter to the namely. And thereafter, and my lord, at 1.3.2, the next page, second. Related provision of the Electricity Act 2003. This code is made under the provision of section 181(2)(10) of the Electricity Act, which provides the state commission shall make electricity under section 50 of the Act. My lord, at 5C, as provided in the section 50 of this Act, this code shall also include the following such other matters related to supply electricity to a person. Page 3 at 5, section 55, use of etc. meters, then section 56, disconnection of supply in default of payment. So my friend's argument that my notice was not under 8.2.1 but was under section 56. My lord, section 8.2.1 is our AERC supply code. The parent act is the Electricity Act, and from the supply code is born, and we are specifically said in the section itself that we are complying with the section 56 of the Act with regard to this purpose. Thereby, my lord, the notice period, my lord, I would like to read section 56 and 8.2.1. The language of both the notices is the same. May I read, my lord?
That's all. Which page?
Ma'am, my lord, page section 56 of the Electricity Act and 8.2.1 of the AERC. That will be page 97, my lord. And in the Act, it will be page 34. My lord, first I would like to read the section 56, if my lord permits. Page 34.
Yes.
Where any person neglects to pay any charge of electricity or any sum other than a charge for electricity due from him to a licensee or the generating company in respect of supply, transmission or distribution or wheeling electricity to him, the licensee or the generating company may, after giving not less than 15 clear days notice in writing to such person and without prejudice to his right to recover such charge or other sum by suit, cut off the supply of electricity and for that purpose cut or disconnect any electric supply line or other works being the property of such license or the generating company through which electricity may have been supplied, transmitted, distributed, or will, and may discontinue the supply until such charge or other sum together with any expenses incurred by him in cutting off and reconnecting the supply are paid but not longer, provided that the supply of electricity shall not cut off if such person deposit under process an amount equal to some claim from him, electricity charges due from him for each month calculated on the basis of average charge of electricity paid by him during the preceding 6 months. Now, my lord, the same language is in 8.2.1.
We continue to.
Yes, ma'am.
Only my lord 30 bighas of my lord land. They say under the
Then, then what do they propose?
My lord, my lord, they have said my lord that non-cadastral areas all are my lord, the erection my lord that process my lord has been always been completed.
No, but but
Just a moment, I didn't get you. Please come this side. I didn't get you.
Lordship, my lord, that non-cadastral my lord village, the erection has already been completed. My lord, that some of the portion, those who have the my lord that dark numbers, my lord, 1, 2, I think.
Whatever we will not be so
Some dark number they have the my
No,
lord
I
that.
think what honorable court is saying is, now let there be an, demarcation of the land.
No, he says that demarcation has already been held. Just for,
No,
you're saying.
no, I don't think so. my lord.
Demarcation is no, my lord, the non-cadastral area demarcation is not been done, my lord. It cannot be, my lord, done because my lord, it is a non-cadastral area. My lord, it is a survey report.
No,
My lord, they have to
no,
done
no.
the past survey.
No, what I'm trying to ask you is that you see, there's schedule A and schedule B.
Lordship,
Correct. So now you say that you have done your eviction.
lordship. In the
From
Would
the
it-
non-cadastral part, they said they
would
have
it-
done it.
Would
No,
it mean-
lordship, schedule B is a completely non-cadastral, my lord,
It's okay.
village.
So are you doing, are you evicting the petitioner from schedule B?
Lordship,
You are evicting him.
lordship. That all the my lord, the non-cadastral, my lord, area, their eviction, my lord, has been completed. My lord, as per my instruction.
No,
My lord,
that is
in
what
the
was
A,
recorded in last order also, my lord.
in my lord, schedule A, my lord, there is a some portion of the are my lord, other non-cadastral and the some other my lord cadastral. My lord, that the petitioner, as per the information I have received, there is a my lord 2 villages. My lord, one is my lord, lordship, they have Sorotari, Enco village, and my lord Sorotari. My lord, the Sorotari, Enco village, they did not my lord that mention in the my lord that petition lordship. And my lord, lordship, my lord, can it be fixed? My lord, that they have been prepared the my lord that parawise and other instruction, my lord. Today, my lord, he is busy in the my lord some other program. Lordship. Next week, the program what is well, next, my lord, that Tuesday or Thursday, lordship.
Because you see, what I
Otherwise, my
require,
lord,
what I
we
require
want-
is a very clarity. You see, the case of the petitioner, you have understood.
Lordship,
Schedule A and schedule B.
lordship.
Correct. So you have 2 ways to look at it. Number one, you say that the entire land is enclosed land. Correct.
No,
Schedule
they
A.
say schedule
No,
B.
no. What I'm saying is that assuming that schedule A or schedule B, whatever is enclosed land, you have clarity what is the enclosed land of the government. Second is the clarity as to whether you propose to evict him from other land which is not a government land. That is the second thing. It would not include land on which you have given notice to for eviction. Correct.
Lordship.
So the second land is that part. And the third part is that out of this schedule A and schedule B land, is there any eviction left out against the petitioner?
My lord, that instructions, my lord, that
Because you
I
see,
don't have
if,
law.
no, because you see, the intention is very clear
lordship.
that if someone has a private land where he wants to utilize it in his own manner, then the government should not come in the way unless it is not a government, unless it is a government land. Correct. So that is the reason
So
I am
as
trying
per
to
my
make
lord,
it very clear.
My lord, let me put it in perspective, my lord. My lord, we claim that is 130 odd bigha of land is a patta land which belongs to us. Now they claim that no, part of mostly of the schedule B land is a non-cadastral, therefore it can be patta land. That is the instruction which my landlord friend has received. Now, my lord, are we not entitled to one small notice that this is, you are, running a cement factory? Now, this is the position. Please explain why we should not take any action. Well, where that action was taken. My lord, we are paying 83 crores of revenue to the state. And we are not, I mean, we are employing more than 200 people. Everybody will be affected, man. That's why I'm saying. All right, by all means, you have the authority to take any action according to law, but it must have some semblance of respectability. Well, all of a sudden, somebody comes, stops our factory. What is this? Therefore, my humble submission is, my lord, let them file a proper affidavit. We are not objecting. But in the meanwhile, my lord, at least we should be allowed to run the factory, my lord. End of the day, if it is a government land, we'll have to leave it. But question is,
It will ask you to postpone for about 4 or 5 days when they file their affidavit.
yes,
Because otherwise, if we change the status quo, it creates a lot of
something
difficulty.
like prejudging the issue. Let them file the counter by Monday, my lord, because we are in a hurry. Or at least some positive,
This,
something in the form of instruction.
Along this IA first.
One.
IA, heard Mr. NLD Chaudhary, Learned Counsel for the petitioner, sorry, applicant. Also heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr.
My lord, Rupam Das, Rupam Jyoti Das.
Arjit Das, counsel for the opposite party number 1, 2, and you are appealing for Purvanchal Cements, Badal Rabha also no.
I am appealing for all the 4 petitioners.
So there are 4 petitions, okay, for the opposite parties. So the opposite parties are the petitioners in WBC 2440/2023. Next, this interlocutory application is for impleading the applicant as respondent number 5. Stop. It is projected that in paragraph 59 of the writ petition, the name of the applicant has been mentioned. Next paragraph. Though the Learned Senior Counsel for the opposite parties have objection to the impleading in view of the nature of relief sought for, but considering that the name of the applicant appears in paragraph 59 of the writ petition, connected writ petition, this application stands allowed, and the applicant is impleaded as respondent number 5 in the connected writ petition. In the writ petition, you say, Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. Arjit Das, counsel for the petitioner. Also had Mr. R. Pujari, Learned Standing Counsel for the revenue. You are as government advocate.
Lordship, I appear on behalf of respondent number 2, 3, and 4, Lordship. My Pujari is respondent number 1.
Acha, R. Pujari, respondent number 1, and Mr. J. and Dick, Standing Counsel for respondent numbers 2, 3, and 4.
2, 3, and
4. You're also there with him.
I go to the.
My Lord, R. Pujari and she will respond number 1. I am for the government 2, 3, and 4.
Oh, okay. Next paragraph. In view of the order passed today in the connected IS Bill 1432 of 2023, or the registry shall implead the applicant in the said interlocutory application as respondent number 5 in this writ petition. Next paragraph, pending.
The idea was to implead them as intervener.
Is this intervening application? No, I did not see.
No, okay, it's okay.
No, I did not see that.
Because basically, my lord, they cannot claim any relief in our thing. They can only have their say in the matter.
That is well settled. Pending the implead from formal correction of the cost title, the letter formal notice we issued on respondent number 5, return forthwith without requiring the petitioner to take any first steps on respondent number 5. Next paragraph. The learned senior counsel for the petitioner expresses some urgency in the matter as the industry of the petitioner has been stopped, which is creating a hindrance for the which is affecting them immensely, as the production is not only production is stopped, but their staff sustenance is also at stake. Next one. The Senate Standing Counsel for the Land Revenue Department.
Lordship, my lord, I received the instruction from the circle officer, respond number 4.
No, you, what should I call you? Standing Counsel for? Achha, for government advocate, you are appearing as government advocate?
Lordship.
Achha, the government advocate appearing for respondent numbers 2, 3, and 4 has submitted that he has received instructions from the circle officer and would file an affidavit in opposition within
At least my learned friend can place the instruction. Because he haven't received any written instruction as.
But our telephone instruction.
but when?
By Monday, instruction he can bring by Monday, my lord.
Lordship, can you fix it on Tuesday?
On
my lord?
Tuesday,
Tuesday.
okay.
Tuesday? Okay.
I can put you the
Oh,
instruction.
Affidavit in opposition and probably got instructions.
Yes.
On Tuesday will be 30/5/2023. Your affidavit can be filed by then? Mr. Chaudhary?
Yes, my lord.
Uh,
My lord, I shall file within 7 days, my lord. I try my level best. I'll done Monday, my lord.
No, because you see that the industry
Yes,
is
ma'am.
closed. That is the difficulty.
Yes, ma'am. Friday, my lord, can it be? Kukurbar is a brother.
Or let it be on Wednesday.
Yes.
Wednesday. The respondent number 5 may also respond by then. Next paragraph. The court is inclined to provide that in the event the matter cannot be heard on the set date, so the prayer for interim relief to be taken up on this.
My. Deeply.
Yes, Mr. Sahu. Oh, yeah, Sharma was on that. Yes.
Hello, may I start?
Yes.
My lord, I was on the provision of 8.2.1, my lord.
Yes.
The language in 8.2.1, that is disconnection due to non-payment of bill amount, is absolutely similar and is parameter with section 56. And section 56 being a central act. And we as a on the provision of 1.2.3, we have already specified that section 56 will be applicable with regard to ARC.
8.2.1 you are saying is parameter to 56.
Yes, my lord. And for that 1.3.2 related provision to the Electricity Act 2003, section 56, disconnection of supply and default of payment. At page 2, this code is made under provision of section 181 to 10 of the Electricity Act, which provides that the state commission will make electricity code regulation section 50 of the act, and there at C as provided at page 3, my lord. Page 3. as provided under section 50 of the Act.
This we have already noted.
Yes, my lord. So now, my lord, I would like to take to my affidavit in opposition that I have filed, my lord.
Yes.
My lord may see the first bill, my lord, and that is at page 27. Under section 56(1) of the IE Act 2003, power supply to your premises will be disconnected at any time due to non-payment of area amount, ignore if already paid. And my lord, nowadays, the electricity bills are provided online. The once you give your consumer ID, the electricity bills comes online, my lord. These bills, they come online. So this 171 he's been attaching it to, that you have not affixed the bill, you have not given the bill. My lord, nowadays the bill even comes in the mobile by that your bill is pending under the registered mobile number.
This is now, that was then.
Yes, this was 2020, my lord.
That time you had.
That
this.
time also, yeah, we had the same thing, my lord.
Okay.
This is 2 years back, my lord. This is
No,
2020.
I don't understand because.
Yes, I understand, my lord. But then also we had the same thing. And my lord, again on 16/7/2020, my lord, we had issued him another bill that under section 56(1) of IE Act 2003, power supply to your premises will be disconnected at time due to non-payment of area payment if ignore already paid. Thereafter, again on 1/7/2020 to 1/8 on 13/8/2022, we gave him the same bill. Again the same format bill. This was a normal bill that had been continued. May I go on further, my lord?
Yes.
Yes. So, my lord, all my bills has one reflection that my notice under section 56(1) was with the bill itself. And with that, my lord, that he is saying a separate notice would be required. For that, my lord, I would like to rely on the judgment of assistant engineer, my lord. The first versus Rahmatullah Khan alias Rahamajula.
Yes, this you have already read.
Yes, my lord. No, my lord, I just want to emphasize one other paragraph of it. My lord. The present civil, page 10, paragraph 6.2. The present, may I read, my lord? The present civil appeal pertains to interpretation of section 56 of the Act, which read as follows. The next page, my lord. Section 56 provides for disconnection of supply in case of default in payment of electricity charges. Subsection 1 of section 56 provides that where any person neglects to pay any charge for electricity or any sum other than a charge of electricity due from him to a license or generating company, the license, after giving 15 days written notice, may disconnect the supply of electricity until such charge or other sum due, including the expense incurred, are paid. However, the disconnection cannot continue after the amount are paid. Now, this amount that is paid, that is required, is PDC, the permanent disconnection, my lord. Now, with that reference, my lord may see 6.4. Now, 6.3, the obligation of a consumer to pay electricity charges arises after the bill is issued by the licensing company. The bill sets out the time within which the charges are to be paid. If the consumer fail to pay the charge within the stipulated period, they get carried forward to the next bill as arrears. My lord, all the bill that was issued to the petitioner here had an arrear of the earlier bill. That is categorically, my lord, is reflected in our charge breakup. I would like, again, my lord, I would like to take to my affidavit in opposition, my lord. Page 27.
We take your word for it.
Yes.
We did not spend our
Yes.
time here.
So my lord, our arrear was continuing. And thereafter, my lord, as per 6 months has already been gone by, and there was a more than that, then we gave a notice to him under 8.2.2, my lord, page 98.
Yes.
Yes.
My lord, page 98, J.
Yes.
Below that, provided notice period for all disconnection shall be 15 days, bracket, except in the cases where disconnection is requested by consumer, unless specific provision of shorter or longer notice is provided in any rule or regulation or any act for disconnection under a specific reason as mentioned under subsection D and G above. However, the supply shall be disconnected only if the cause of the disconnection is not removed within the notice period. This notice period is, my lord, the 15 days notice that is there within the bill. There we have said that you have to clear your dues within the 15 days, otherwise disconnection will apply. The licensee shall intimate the consumer in case of his temporary disconnection in the format 18 of the SCADE code within 24 hours of the disconnection. My lord, this format 18, my lord, will page at page 205.
Yes.
My lord, our intimation to consumer after temporary disconnection supplied to the petitioner is at page 35, my lord, of my affidavit in opposition. It's absolutely similar to the one we have given. So there is no discrepancies on our part with regard to the intimation. And we have categorically stated that
This is same as page?
205, my lord,
No,
form
same as page?
35 of my affidavit in opposition, my lord.
Yes.
Where we have stated that this is to inform you that your supply has been temporarily disconnected with effect from 20 August 2020 due to the following reason: non-payment. You are requested to remove the cause of disconnection and intimate this office at the earliest. You are requested to pay a sum of rupees 13,706 toward disconnection and reconnection charges. If any dues are to be deposited with a detailed breakup. If the cause of disconnection is not removed to the satisfaction of this office and above amount is not paid within 45 days of this notice, your supply will be disconnected permanently without any further notice. Now, my lord, in the writ petition, they have served as a legal notice. In the legal notice, at para 2, at page 18, my lord. There is an admission from him himself that he knew about the disconnection. That the power connection, the power connection of the aforesaid unit was disconnected sometimes 2 years back by the office of SDO GEC Jew Road. However, even after the disconnection of electricity connection, the office of the SDO GCC Jew Road continued to generate electricity bill. As my senior is settled in Manipur for long, he was not aware of the fact the power connection has been disconnected. And even after disconnection, the office has been generating electrical. Anyhow, we went to the office to inquire about the matter on 29/3. We were told the person who was sitting in the bill receipt section that 29/3 was the last date of payment of the bill. Now, this bill is, my lord, the PDC bill that is in their annexure itself. That is at page 14. May I read, my lord?
Just one minute.
Yes.
Which page?
My lord, page 14, my lord.
Yes.
My lord, there's a billing details. There we have categorically said that this is a PDC bill. That is a permanent disconnection bill, my lord. PDC bill at page 18. So, my lord, there is a difference in both the bills, if my lord may see. In the earlier bill, which we had sent him in 2020, my lord, there was a section 51 notice that was been there in the notice. But in this bill, after permanent disconnection, there has been no such kind of a notice because the disconnection has already happened. Now, the question arises that he had received this bill, but he has not received his earlier bills. And he himself has stated in his letter that he knew there was a disconnection for sometimes 2 years back. So he not receiving the notice cannot be true, my lord, because once if he has this bill which we had sent on 14 March 2022, it is the same way we have sent the earlier bills. In the same way we intimated the earlier bills. And as per section 56(1), that the due as a section 51,
it can only be a presumption of issuance. It can't be a presumption of service. Presumption of service, there is something more you'll have to show. Presumption of issuance may be there. You see, presumption of service, we are at presumption of service.
My lord.
What Mr. Sahu is arguing that if it is not served, that becomes illegal. That is what his argument is.
My lord, I absolutely understand this, my lord. But the main question that arises here is that how does a mode of electricity bill are given? It is given online. It is given online. It is given to send to every mobile number. And this is I can say on oath, my lord, this is how it is, and it's been going on from the last. So a person whose registered mobile number is there, he gets the electricity bill there. The giving of a hard copy or giving the question of that does not arise, because the electricity bill are always given to a consumer through his mobile and it is generated, and a message also comes in the phone that the bill has been received. So there on that part, my lord, the service, our being service, we complied with it. And he has been received of it, because he cannot say that mobile number or the consumer number which he is attached to, my lord, is not there. My lord, as a general explanation, my lord, not today, even 2 years back, my lord, even during the COVID, my lord, when there was a restriction and everything, my lord, a message was sent to everyone that your electricity due is there. And it has been, and it is not only to a single person will not be sent. It is a generalized, everywhere it is sent. And everyone paid their electricity through online at that time by entering the consumer number, my lord. Similarly, in this process also it was similarly done. And that process has been adopted till today. That nowadays, my lord, the concept of smart meters also come in. So taking the assumption under section 171 that I have not received the notice because you have not affixed it, my lord, on account of receiving of bill, my lord, I would have accepted if my lord would have done, I would have 94 where the connection was, my lord. This is the process that we have universally accepted entire state, where we give bill through our electronic platform, and they are aware of it, my lord. So, my lord, this bill, the PDC bill, was also sent in the same format, the way the earlier bills were sent, my lord. So if the earlier bills, if this bill has been received by him, So the earlier bill will be automatically received by him, my lord. That is where I'm the conclusion that I'm drawing to, my lord. And my lord may now take into page 15, my lord. Page 16, madam, page 16.
Yes.
There is a bill of RCDC payment, my lord. Reconnection and disconnection payment, which he paid for 600 rupees. Now he is claiming that I have paid this for my reconnection charges. But as per the judgment and as per section 51, the expenses that were incurred, that also has to be paid. And that is why this bill amount of 600 was paid, my lord. Section 56(1) clearly states that to serve without prejudice to right to recover such charges or other sum by suit, cut off the supply electricity and that for purpose, cut off any line or other work or any other sum. That is the expenses that we have incurred. And that is the charge we are. My lord, I'm still submitting, my lord. My lord, if he apply for a fresh connection, my lord, we will give him. But he is only harping that he needs his old connection, my lord. That has already sailed, the boat has already been sailed, my lord. Because in 2 years' time, when the disconnection happened, we followed the procedure, section 56(1), the electricity bill was issued. It was not only in his case that we are giving the section 56(1) here. To every bill that is issued to a consumer in that period and even now, section 56(1) is stipulated there that if you do not pay the bill within 15 days, your connection will be disconnected. And my lord, a citizen itself knows that I have not paid the electricity. What is going to happen? I may face disconnection. So I may rush and pay my electricity bill, my lord. So he not being doing that and now taking the habit, I have never received the bill. My lord, that assumption is been drawn by him, my lord, because it is an universal method of sending notices, my lord. Now, my lord, my lord, senior has also argued on this with regard to that it was never due on him, my lord. For that, I would like to, my lord, just 2021 SSC Online SC 870, my lord. My lord, 2021 SSC Online SC 870.
Name of the parties?
My lord, Prem Kotex versus Uttar Haryana Bijli Vitran Nigam Limited. I have given a copy, my lord.
Okay.
In the first half. My lord, at page 11, man. Second page, paragraph 11, my lord. So section 56 has been contemplated. In Rahmatullah Khan, my lord, the earlier judgment which I was referring to, 3 issues arose for consideration of this court. They were, what is the meaning to be ascribed to the term first due in section 56(2) of the Act? In the case of a wrong billing tariff having been applied on account of a mistake. Third, when would the amount become first due? Third, whether recourse to disconnection may be taken by the licensee after lapse of 2 years in case of a mistake. These are the 3 issues that were decided there. On the first 2 issues, this court held that though the liability to pay arises on the consumption of electricity, the obligation to pay would arise only when the bill is raised by the licensee. And that therefore the electricity charges would become first due only after the bill is issued. Not on served, my lord, on issued, when I have issued it. So I have already issued the bill to him. Even though the liability would have arisen on consumption. On the third issue, this court held in Rahmatullah Khan Supra that the period of limitation of 2 years, that is not applicable in my case, my lord. But still I'm reading it. From the date on which the electricity has become first due under section 56(2), this court also held that section 56(2) does not preclude the licensee from raising an additional or supplementary demand after the expired of period of limitation in the case of a mistake or bona fide error. My lord, what had happened in this case, the tariff that was calculated was wrongly calculated, and after 2 years, the the or respondent herein had charged. The Supreme Court said you cannot do it because after limit of period of 2 years, you cannot charge them. But in my case, he has never disputed that my bill is wrong because he has paid the amount. Now the question arises that when would your assumption of due would arise? When I have issued it, not when you received it. My lord, then I would like to take paragraph 15, my lord. May I read?
Yes.
My lord, I'm sorry, I'll let 13 first, then 15. Despite holding that electricity charges would become first due only after the bill is issued to the consumer, para 6.9 of the SSC report, and despite holding that 50 does not preclude the license from raising an additional or supplementary demand after the expiry of limitation prescribed therein, the case of a mistake or bona fide error, this court can that what is barred under 56 is only the disconnection of supply of electricity. In other words, it was held by this court that in a penultimate paragraph, the licensee may take recourse of any remedy available in law for recovery of additional demand, but is barred from taking recourse of disconnection of supply under 56.2, not under 56.1, my lord. Only 56.2. That if I have wrongly billed him after limitation after 2 years, I have not done that. I have made my bill under 56.1, then I have given him a PDC. This is a permanent disconnection. Thereafter, at paragraph 15, therefore, the bar actually operates on two distinct rights of the licensee, namely the right to recover and right to disconnect. The bar with the reference to information, the right to disconnect, is actually an exception to the law of limitation. Under the law of limitation, what is extinguished is a remedy and not the right. To be precise, what is extinguished by the law of limitation is a remedy through a court of law and not a remedy available. If any dehors a court of law, however, Section 56.2 bars not merely the normal remedy of recovery, but also bars the remedy of disconnection. This is why we think that the second factor is an exception to the law of limitation. So, my lord, precisely the Supreme Court has pointed out that it is only with regard to 56.2 that you cannot do disconnection. And my lord, my petitioner's case herein does not fall under 56.2, my lord. It falls under 56.1. And in the 56.1, my lord, the steps that we have to take into, my lord, is that we have to issue notice to him. 15 days if you do not pay. That notice is price of our bill. We waited for 6 months. More than that, he did not pay. We intimated him a temporary thing under format 18. He did not pay. And there, when he issued the PDC, he said, why have you disconnected me? Now reconnect me. So already a boat has been sailed, my lord. We cannot do anything. And last submission, my lord, is regard to that whether we have the power to reconnect or resupply after permanent disconnection, my lord. My lord, page 97, my lord. Disconnection. Disconnection can be two types: temporary disconnection, my lord, 8.2, and then my lord, 8.2.3, reconnection, restoration of power supply. It's page 99, my lord.
Yes.
If any service is disconnected on account of non-payment of electricity charges or any other charges due to license, the consumer has to pay the charges for disconnection and reconnection. The license shall restore the electricity within 24 hours in urban areas and within 48 hours in rural areas after the consumer has produced a proof of payment of charges by consumer or compliance report on removal of any defect or discrepancy. However, restoration of power supply will be attended only between 8 AM and 6 PM, except in case of electricity essential like water. My lord, this 8.2.3 is with temporary connection, because my lord, if follow page 99, permanent disconnection is a separate heading. So my learned friend here and my learned senior is saying that you have the power of reconnection. We only have the power of reconnection only with regard to temporary connection. Otherwise, my lord, this supply code would not have bifurcated the temporary connection and permanent disconnection, my lord. And therefore, my lord, 8.3 at B, it's written, my lord, if the cause of which the supply was of which the supply,
Where?
my lord, page 99 only, my lord, 8.3, permanent disconnection. My lord,
Hmm.
8.2.3 is a reconnection, 8.2 unauthorized reconnection, then permanent disconnection, my lord. The supply shall be disconnected permanently in following cases. On the termination of the agreement, B, if the cause for which the supply was temporarily disconnected is not removed within the notice period. If the cause of which the supply was disconnected was not removed within the notice period, the notice period was already over, provided that if a service of the consumer remains continuously disconnected for 180 days, not being a temporary disconnection upon request of a consumer, the agreement shall be terminated on the expiry of 15 days or after the expiry of initial period of agreement, which is later, without prejudice to the right of the licensee or the consumer under the Act for recovery for any amount due under the agreement. After termination of all the agreement, the licensee shall intimate the consumer in format 20 of this code. So my lord may see, we have to only intimate after format 20 if there was an agreement. If they, because we do not have an agreement with him. Agreement is there only with the companies or other power big distributors. Only with him we have a relationship of a consumer with regard to payment of salary by paying security deposit. So his harping that you never intimated me after format 20. My lord, my format 20 may also be looked on, my lord. Page 207, my lord.
Page
207, my lord, format 20.
Yes.
My lord may see, at 206, there's a request of permanent disconnection and termination of agreement. And there's an intimation to consumer after termination of agreement. So in his case, we do not have a termination of agreement, my lord. So the question of giving a format 20 does not arise, my lord. My lord, that is all, my lord.
Yes, Mr. Sarma, anything in reply? Anything in reply?
Yes, my lord, your lordship, I'm very sure it is to say that my friend has repeatedly tried to misguide this honorable court. Your lordship, my friend has said that I said that I have not received the bills. I've never said, nowhere said that I have not received the bill. What I'm saying is that I have never received the notice of disconnection. That's what I'm saying. I've nowhere said, my lord, neither in the legal notice, nor in my pleadings, nor in my rejoinder affidavit, that we have not received the bills. We have always been receiving it, as informed by the caretaker. Now, my lord, your lordship, one great lacuna, your lordship may kindly see on their part. What they are saying is that, my lord, your lordship may kindly see the rules, the regulation 8, my lord, disconnection 8.2.2, disconnection on other regions. Your lordship may kindly see page number 101. 8.2.2. The last sentence just above 8.2.3. Shall I read, my lord? My lord, the licensee shall intimate the consumer in case of his temporary disconnection in the format 18 of this code within 24 hours of the disconnection. Within 24 hours of the disconnection. Now let us come to the format 18, my lord, their affidavit. First of all, I'm saying that it is a manufactured document, and all throughout I've been saying so. But even assuming you look for page number 35, my lord, page number 35. Now their disconnection, my lord, format number 18, my lord, they disconnected temporarily on 28/2020, and this, your lordship, 24 hours, your lordship, after 1 year, more than 1 year they have intimated. They're intimating, and they are saying that they have followed the rules.
Disconnection on
Disconnection on, my lord, 28/2020, second para, my lord. This
28.
This is to inform you that your supply has been temporarily disconnected with effect from 28/2020. And my lord, due to following reasons, so and so. And this is dated is received, dated is 16/11/2021. There's top right side, my lord, at the top right side. And the regulation itself says the licensee shall intimate the consumer in case of his temporary disconnection in the format 18. This is format 18, my lord. It is indicated at the top, format 18, top page number 35.
Yes.
18. So it is not 24 hours, it is after more than 1 year, my lord, the intimation. Now they are intimating after more than 1 year, that is 1 year, 4 months, 3 months, that it has been disconnected. Now then, my lord, lordship may kindly see, they're all throughout they have been trying to mislead this Honorable Court. Your lordship may kindly see the page number. My lord, your lordship may kindly see the order dated 27/4/22. Their submission has been recorded by this Honorable Court. The note sheet, my lord, 27/4/2022. 27/4/2022.
Yes.
My lord, the second para. Your lordship may kindly see last sentence of the second para. But due to the non-payment, my lord, of the dues in spite of the notice issued to the petitioner on 16/11/2021, the concerned meter in the residence of the petitioner at Orient Place number so and so was removed prior to the payment of the bill on 29/3/2022. This is what they submitted before this Honorable Court, and the factual position may be seen at page number 14, my lord. Page number 14. Page number 14. Annexure A1, page number 14. At the top right side, my lord. Page number 14 of my writ petition, my lord.
Yes.
Top right side, meter status, my lord. Lordship may kindly see last 1, 2, 3, 4, 5, 7th line. Meter status, it is running. It is meter status, they are running, and they are submitting before the court that it was removed. And if removed, then their own fault, my lord. And why they have been misleading this Honorable Court right from the beginning, my lord, right from the beginning, all throughout. They are saying that there is an interim order directing me to take reconnection of trace connection, which are never there. And in fact, my lord, this Honorable Court directed, given them liberty on 3 occasions, my lord, to liberty to reconnect if they so choose to. Your lordship may kindly see the first liberty was granted. Your lordship may kindly see, just to avoid the problem, my lord. It was on 21/4/22. His lordship, Justice Pathak said, pendency of this writ petition shall not be a bar to the respondents in the APGCL to restore the electricity connection. Then again, my lord, again this Honorable Court, my lord, again pass this order again, my lord. Similar order, my lord.
Date of removal is when?
Removal, my lord, the temporary removal is in their format 18 they have given, my lord. Page 35, my lord. Page 35, 28/2020. 28/2020, my lord. Page number 35, second paragraph. This Honorable Court, my lord, again this Honorable Court again on 31/5/22 also observe that in the meantime it is made clear that pendency of the writ petition shall not be a bar for the respondents APDCL to consider the prayer of the petitioner on various occasions. Then, my lord, I don't know, there are so many, my lord, so many. My case is that notice was never served to us, and it was, if at all they say it is served, it was not as per section 171 of the Electricity Act. Now, my lord, we have never said that bill was not served to us. Then, my lord, notice, not serving of notice, my lord, this comes under violation of natural justice. Violation of natural justice can be avoided sometimes. My lord, can be some avoided. Honorable Supreme Court has held that sometimes it is useless formalities. But, my lord, in the present case, it is not a violation of natural justice. It is a statutory provision, both in the regulation as well as the Electricity Act. It is a statutory provision, my lord. Then, my lord, Then my lord, 821, disconnection of non-payment of bill. When a person neglects to pay any charge of electricity or any other sum due from him to a licensee by the due date mentioned in the bill in respect of supply, transmission, or distribution wheeling of charge, the licensee may, after giving not less than 15 days clear notice in writing, my lord, clear notice in writing to such person and without prejudice to his rights to recover such charges or other. So, my lord, 15 days notice in writing and inclusion in the bill, that is also of section 56A, my lord. Then and 56 is totally different. It doesn't say permanent disconnection or temporary disconnection. It says disconnection. Doesn't say temporary disconnection. Temporary disconnection is in regard to only by their own regulations, my lord. Their regulations. So, and this bill which is shown, the bill in the inclusion of this notice of disconnection in the bills can never be said to be a notice under section section 171. And my lord, the judgment cited by my friend is not at all applicable in the present case, because for the reasons that they have not addressed my point, which says that whether they have served notice or not. This they have never been successfully providing this before this honorable court that it was duly served, and as per the law it was served. And my lord, I submitted in the morning, my lord, that the initial, once something is wrong in the initial stage, cannot be rectified at the later stage. I have not given the citation, but I'm giving the Xerox copy, my lord. Kindly, your lordship may kindly see page number 2011 volume 3 SCC. My friend, page number 2011 volume 3 SCC, page 436. Only one para, my lord, para number 37. Yes, my copy. Para 37. It is settled legal proposition that if an order is bad in its inception, it does not get sanctified at a later stage. A subsequent action development cannot validate an action which was not lawful in its inception, for the reasons that the illegality strikes at the root of the order. It would be beyond the competence of any authority to validate such an order. It would be ironic to permit a person to rely upon a law in violation of which he has obtained the benefit. If an order at the initial stage is bad in law, then all further proceedings consequent thereto will be none-est and have to be necessarily set aside. Your lordship, here what I want to say is that the temporary disconnection is not at all as per law. Even if we assume or presume that the permanent disconnection was done after a notice, which they have never done, because section 171 has never been followed. So that cannot rectify the temporary disconnection. And there is, first of all, and lastly, my lord, there is no order of any disconnection. But in spite of this honorable court's order to produce the records saying where indicating the disconnection, my lord, this honorable court was pleased to adjourn this case on 3/11/22 only on this point. The order dated 3/11/22, Mr. S.P. Sharma, learned counsel for the APDCL, praised for an adjournment to produce the record of the case in original, which may contain the decision and the reason thereof as to why the electricity connection of the petitioner was disconnected.
That I have brought in. It has already been pursued by the court.
Well, that's all, my lord. My submission is that the disconnection was totally illegal, my lord. So therefore,
My lord, just one submission. The status that is meter running is, my lord, that is the health of the meter, my lord. I have talked with the engineer also. It is health of the meter, my lord. The status, I'll just provide it to my lord. That is the only health, that whether the meter was running, because sometimes not a meter becomes defective, so the running will not be shown.
This is what is this?
My lord, these are the originals, my lord. The court had asked us for the original to be produced.
my lord, the court wanted not the original record. The court wanted the
This is what
report disconnection order.
My lord, there is no, I have submitted before the court, my lord. For permanent disconnection, there is after, for a normal consumer, there is no format. So how will we produce and there is nothing there, my lord. So that is why
You took the time for producing it.
Okay, this you can return. Okay. Okay, I'll just examine and pass orders. It will be delivered, it will be released tomorrow morning. I'll pass orders today. It will be disposed of. Take some time. I'll take some time to read the.
Yes,
documents.
my lord, I've given my detailed reply to their affidavit in my rejoinder affidavit.
Yes, I've
In
seen.
my rejoinder affidavit. I've given in detail, my lord.
I've seen. Because by the time I upload it, it will be. By
My
the
lord,
time
your lordship may take time, my lord, no problem. my lord.
by the time I finish the order, the computer will be shut down.
It's not necessary that your lordship may pass tomorrow. It can be
No, it's okay. I'll do it.
even
It won't be
thereafter,
pending.
my lord, because I don't want your lordship to.
It won't be pending.
I have waited for so long, my lord, I can still wait.
No, it's okay. But
Lord, I really enjoyed the hearing of your lordship, my lord. I've been missing this court very much, my lord. My
My
lord,
lord,
in
one
fact, in Manipur, my lord, now court is also closed, my lord.
Well,
My lord, there is a turmoil, my lord. There is yesterday again restarted that ethnic violence.
for that reason.
Yes, my
Yes,
lord.
yes.
And tomorrow, my lord,
Right.
yesterday, they tried to burn down the residence of power minister, this PWD minister.
Oh, my situation is very,
What's
very,
the-
very volatile.
Yes, about as per officially, 76% have been killed so far. Officially, unofficially hundreds, my lord.
Okay, defective not available.
So then you would have, you would face difficulty going back.
My lord, airport is no problem. Therefore, till yesterday it was curfew was relaxed till 4 p.m. But from today, I'm
No, but
told
there
that
is
it has
also quite
totally, it has been reimposed.
There is also quite a distance from the airport to.
About 7-8 kilometers. my lord.
7-8 kilometers.
My house is just half kilometer from the High Court. Only half kilometer. I'm having just, I can, even during the adjournment, I can reach the court. Very nice. Well, I'm really missing a lot.
My lord, 1 minute, my lord, my lord, that's the status of the meter, my lord, that's 6.3.5, my lord. See, with the status of meter, my lord. 9, my lord. Status of meter, okay, defective. That is where they're running. That is how the bill should be. The format is there.
Okay.
6.3.
They have violated various provisions. 24 hours intimation, they have taken 15 months.
That is with effect from my lord.
Anyways,
Hello, Blazin.
Acha.
My lord, I have
This
given
is-
one book.
This is page 74. You just give your name to the court master. Not true.
Also, well, man.
Nine and 10.
Nine and 10.
9 and 10.
Yes.
Before my learned friend starts. Both these 2 meters are covered by your lordship's judgment passed from 22/5/2023, the Isundra Hospital.
Oh, yes.
Here this service meter lordship.
Okay.
And that rate appeal 188 of 2022.
Okay. Yes.
Yes, my lordship.
My lordship, there are two. First of all, I'm grateful to my lordship for allowing virtual hearing.
Yes,
My lordship, there are two matters, serial number 9 and 10. They both are tagged with each other.
yes.
I request if my lordship can take serial number 10 first. That is Shashri Constructors Private Limited.
Yes.
If they both are service tax matters, what in serial number 10, this is Shashri Constructors Private Limited, writ petition number 3967 of 2022. My lordship, I have been awarded a contract by Engineer Projects India Limited for construction of bridge.
Just a moment.
My lordship.
I think we have to hear on the maintainability first.
Yes, my lordship. Maintainability, I'm just coming to that because this is covered by my lordship's own judgment also, where my lordships have remanded the matter to the commissioner for passing fresh orders or rectification orders.
Okay.
Yeah. So just that's where for maintainability, my lordship have to just take my lordship to the facts, brief facts.
Yes.
My lordship, I have been awarded contract by Engineer Projects India Limited for work for construction of bridge. These are works contract, my lordship. And my lordship are aware that works contract, there is an element of sale of goods and then there is an element of provision of service. As far as sale of goods are concerned, my lordship, VAT has been paid. That is, I have enclosed necessary proof also with my writ petition. As far as the service part is concerned, my lordship, my humble submission is that the services provided me are exempt under mega exemption notification. In the last hearing, my lordship, I had produced a letter issued by Ministry of Home Affairs. If my lordship have the copy, otherwise I will request my learned colleague to hand over a fresh copy. Letter dated 8th July 2015.
July 15, yes.
My lordship, this is a letter issued by Ministry of Home Affairs, Department of Border Management. It says, please refer to EPI and letter number so-and-so dated so-and-so on the above mentioned subject. The matter has been examined. It is observed that the Bailey bridges are presumably used for general public also, as they are intended for use of general road transportation. Hence, the construction of these bridges are not liable to service tax. This is a clarification, my lordship, issued by the government itself. This is by Ministry of Home Affairs. I thought that Ministry of Finance has not issued, but this has been issued by Ministry of Home Affairs. Government itself has clarified, the ministry which has awarded me this contract through Engineering Projects India Limited.
Yes.
My lordship, now I come to the petition. As far as my I request if my lordship can come to annexure 143. This is the contract that has been awarded to me. This has been awarded by Engineering Projects India Limited. From the subject itself, it is clear that this is for construction of bridges. Page number 43. There are two contracts. LOI for design, manufacture, testing, inspection, painting prior to dispatch, transportation, supply to site, unloading, erection, and final patch of painting at site of 5 number Bailey bridges at various locations from so-and-so to so-and-so along IBB in the state of Mizoram, including design and execution of associated civil works, all complete on turnkey basis in all aspects. So it is regarding this very contract itself, the Ministry of Home Affairs have issued a clarification that this is not liable to service tax. Second contract is at page number 5. That's identical, so I'm not reading that out, my lordship. I had produced these contracts before the commissioner. These show cause notices, my lordship, have been issued basis the income tax data. It is not that they have conducted some investigation, some data they have taken from income tax, might form 26 says, basis that show cause notices were issued to me. I request if my lordship can, just before taking further, page number 47 is the summary of invoices, my lordship. It has last two columns, if my lordship can see, income tax, TDS, which was deducted, then VAT deducted at source. So VAT has also been paid, service tax sale component. They have demanded service tax from me on the entire consideration, my lordship, including on which part I have already paid VAT. Then I request if my lordship can came to page 107, that is the impugned order. Page para 4.4. In their written reply dated 17 February 2022, they stated inter alia that they provided construction service to Engineering Projects India Limited. They also stated that the said service provided to Engineering Projects India Limited was awarded to them with a work order so and so. They reproduced an extract of the said work order as follows, which I just read out. They contended that the said services were covered under the mega exemption notification number so and so. They pointed out that for financial year 2015-16, the turnover as per Form 26 AS was 15 crore 5,154, whereas the turnover as per audited balance sheet was rupees 13 crore 56 lakh 51,625. Then my lordship can skip para 4.6 and 4.7, then 4.8. This is his finding. I find from the above submissions of the notice that basically they have claimed that the turnover of rupees 13 crore 56 lakh 51,625 as per their audited balance sheet, or their turnover rupees 15 crore 5,154 as per Form 26 AS were against work order so and so awarded to them by Engineering Projects India Limited for design, manufacture, testing, inspection, painting prior to dispatch, transportation and supply to site, unloading, erection and final patch-up painting at site of 5 number of Bailey bridges at various locations along IBB in the state of Mizoram, including design and execution of associated civil works on turnkey basis. They enclosed copies of the above work order. So he admits that I have enclosed copies of the work order. However, I find that apart from mentioning that their above turnover for financial year 15-16 was in relation to the above two work order, they did not submit any documentary evidence such as bill, bank statement or any other such document to substantiate the claim. Mere referring to the work order is not sufficient to prove that the turnover was derived from that particular work order. Therefore, I do not find that the argument of the notices that their above turnover is covered under the notification number so and so acceptable. In view of the above, I hold that the noticee is liable to pay service tax amount to rupees so and so so and so. My lordship, just basis this one paragraph, he has confirmed the demand of 2 crore 70 crore. During the personal hearing, he has not asked me to produce any document. Now I request if my lordship can also come to Form 26A, because other than this revenue, I had no other revenue except for interest income. My lordship can come to page 68. This is Form 26 AS, my lordship. Serial number 1 itself, Engineering Projects India Limited. Part A, details of TDS. Then second is Bank of India, third is Punjab National Bank. So these are interest income. They are outside the ambit of service tax, even he has not touched upon. As far as my revenue from operations are considered, it is only Engineering Projects India Limited. Other than this, I have no other revenue. The entire proceedings, my lordship, have been initiated basis this Form 26 AS. If my lordship can see total amount credited paid, it says somewhere around 15 crore 5,154. If my lordship can see this, this is what, and now from the show cause I can take my lordship. 73. Page 73, my lordship, of the show cause, this is the show cause notice, page 73. This amount will match with this form 26A in the table itself. Last, if my lordship can have the table. Page 73, table at the bottom, column 3. So they have issued show cause notice to me basis form 26AS. Form 26AS reflects only revenue from Engineering Projects India Limited. I have produced before him the contract copies. Still he says that I have not been able to substantiate. Now, my lordship, I have also produced letter from the Ministry of Home Affairs, from the government itself, that my revenue is not liable to service tax. In this scenario, my lordship, this matter, and one more thing, my lordship, I now request if my lords can come to their own affidavit and reply. Para 20, page 118. My lordship have that?
Yes.
That with regards to the statements made in paragraph 46 to 46 of the writ petition, it is stated that the petitioner failed to produce documentary evidence before the adjudication authority to show that the amount of which service tax was demanded in the show cause notice was in relation to the work orders referred by them. In the show cause notice, it was clearly mentioned that at the time of showing cause, all evidence upon which they intend to rely should be produced. The copies of invoices and statements which have now been produced before the Honorable Court were not produced before the adjudicating authority. So my lordship, in a way, he himself also admits that now that these services were taxable. These services are exempt. So in this factual scenario, my lordship, I request that this matter ideally should go back to him, because there's a demand of that 2 crore that has been confirmed against me. And now there's a letter from the department itself, which I got in February month only this year, which says that the services are exempt. So in this above factual matrix, he should re-adjudicate the matter. And my lordship, in a similar scenario, have already given a similar direction. If I request my learned colleague to hand over compilation to my lordships on the maintainability part. Is my lordship's own order. It is the GB Chaudhary Holdings Private Limited versus Union of India. Page, it starts at page 52. The relevant part is page 54. Identical set of facts. In fact, my case is better because in my case, government itself has issued a clarification. The court, my lordship, have that? The court has considered the submission made by the learned counsel for the petitioner that amongst various receipts by the petitioner, 3 components are, as already mentioned herein before, are exempted from the incidence of service tax, and prayer made by the learned counsel for the petitioner is that the petitioner may be given an opportunity of placing the relevant document before the authorities. The court is of the concerned opinion that as the provisions of section 74 of the Finance Act 1994 provides for rectification of mistake, the ends of justice would be met to permit the petitioner to avail the statutory remedy as provided for under section 74 of the Finance Act 1994 by applying for rectification of mistake, if any. As already indicated here and above, the court records the objection made by the learned standing counsel for GST. Be that as may, as the Finance Act 1994 provides under section 74 for rectification of mistakes, therefore, without adjudicating the issue raised in the writ petition, the court is inclined to relegate the petitioner to submit a representation before the respondent number 2 in an appropriate manner under section 74 of the Finance Act 1994, and on receipt of such representation, the respondent number 2, that is Principal Commissioner GST and Central Excise Commissionerate, shall dispose of the representation in accordance with law. The petitioner shall produce a copy of order along with this representation and also provide his email address to the respondent number 2 within a period of 2 weeks from today. Considering the upcoming view holidays and on receipt of the same, the respondent number 2 shall dispose of the same within a period of 6 weeks thereafter and communicate his order to the writ petitioner. There are 2 other orders, my lordship, of this honorable court.
You have a copy of this? Do you have a copy of this rules, section 74 of Finance Act.
My lordship, I've tendered one compilation that is for rectification. Mhm. My lordship, in my compilation, it is not there. One I've already submitted. But it provides for rectification, error apparent on the record. If my learned friend has the book, then
You have a book, Finance Act?
Yes.
Show it to me. But I find this section 74 is a power accessible by the authorities. It does not give the power to the petitioner to make an application, the SSC to make an application.
my lordship, this I'm requesting that if my lordships can either send this matter for him for de novo adjudication. Alternatively, I may be permitted to make an application under 74. In that case, if my lordship can give a direction that if I may be
No,
permitted to.
74, you can't be permitted. We can't give you an avenue which is not there in
My
the act.
lordship, my first prayer is of de novo adjudication. My lordship can send the matter back to him for re-adjudication under 73, which is the normal 73 section, which my lordship have done. And there are two more orders that at page 43 of the compilation which I had submitted, where this honorable court had sent the matter for de novo adjudication. Because my lordship, now in the light of this instructions letter issued by the government itself, even the commissioner himself can also correct. Law says that even he also can correct the mistake on being pointed out. As per under 74, my lordship, he himself also can do.
But this Bailey Bridge, is it covered by that exemption notification?
Yes, my lordship. That's what I read that letter from the government itself. Anyway, I will read out the exemption notification also. I had some furnished another compilation also, my lordship, which is there already there on the record.
Yes.
Page 23 of it. Serial. My lordship, have the compilation?
Yes.
Page 23. Relevant part is at page 26, serial number 13. The total 34 pages in it. See, page 26.
Yes.
Serial number 13. Services provided by way of construction, erection, commissioning, installation, completion, fitting out, repair, maintenance, renovation, or alteration of a road, bridge, tunnel, or terminal for road transportation for use by general public. So bridge is covered here, my lordship, and that is what the Ministry of Home Affairs also clarified. Per se, even the respondent number 2 himself also was not disputed. He was only said that no document was produced, this and that. On he has per se, he has also not rejected my exemption claim.
Where is your work order?
Work order, my lordship, is at page 43.
Okay.
My lordship, on the maintainability part, if my lordship wants, I can produce other judgment also. There are 2 more judgments in the similar scenario where this honorable court has remanded the matter back.
Yes.
At serial page 43. The relevant part, page 45. Serial number para 5. A reading of clause so and so of the demand notice goes to show that the objection raised by the petitioner that for the contract work for which the service tax has been imposed, they are exempted from payment of such tax had not been conclusively determined by the authorities. The authorities, on the other hand, appears to have gone on a presumption that as because the materials produced by the petitioner did not make it discernible for the authorities to arrive at such conclusion, therefore the authorities were of the view that the petitioner is liable to pay the tax. The liability to pay a service tax is not upon a presumption, nor can it be based upon a state of indeterminateness on the part of the authorities. The liability to pay a tax has to be conclusively determined that for the given transaction for which the tax is imposed, the noticee is liable to pay such tax, and such taxes are not being paid. As the said determination had not been made, we remand the matter back to the Principal Commissioner CGST Guwahati for a fresh determination. In doing so, the petitioners be given an opportunity to produce any relevant material to show that the contract works for which the service tax has been imposed, the noticee is not liable to pay tax for such transaction, and in doing so, the petitioner to also cooperate with the authorities so that they also can come to a conclusion on the aspect and produce any relevant material as may be desired. After making a conclusive determination, any reasoned order or any further demand notice as may be called for may be issued by the authorities. On the other hand, if the conclusion arrived at that the petitioner is not liable to pay service tax, appropriate reasoned order be also passed in order to substantiate the claim of the petitioner assessee that they are not liable to pay the service tax on any other ground or reason as may be desirable be also allowed to be raised by the petitioners. Similar view, my lordship, is expressed in the next judgment. I'm not burdening my lordship with that judgment because it relies on this order only. There is other judgment, my lordship, too, where there is a honorable court, Supreme Court order, page 39. In this case, the alternate remedy which my learned friend is referring to. Firstly, I have issued that, my lord, it's a settled position in law that an alternate remedy is not a bar for writ jurisdiction under this court. My lordship, in the interest of justice, this court can exercise writ jurisdiction. 39, J.M. Bakshi and Company, Gujarat versus Commissioner of Customs, New Conline, Adada, 2001, 9 SCC 275. The Honorable Supreme Court specifically hold para 3. Normally, the High Court not to interfere in exercise of its jurisdiction under Article 226 when adequate alternate remedy is available. But in special facts of this case, when the demand was raised and the same has been challenged on the ground that it was barred by time, and where the demand is nearly of 46 lakh of rupees, which will have to be deposited before any appeal can be filed, we are of the opinion that the High Court ought to have exercised its jurisdiction and determined the question which were raised in writ petition on merits. In dealing with the contention raised by the appellant, the High Court would necessarily have to consider the contentions of the respondents as well. My lordship, there is a next judgment, State of Tripura, next page, page 40, State of Tripura versus Manoranjan Chakravarti and others, page 41, para 4. For the reasons contained in the said decisions, we hold that the impugned provisions are valid. It is of course clear that if gross injustice is done and it can be shown that for good reason the court should interfere, then notwithstanding the alternate remedy which may be available by way of an appeal under section 20 or revision under section 21, a writ court can in an appropriate case exercise its jurisdiction to do substantive justice. Normally, of course, the provisions of the Act would have to be complied with, but the availability of the writ jurisdiction should dispel any doubt which a citizen has against the high-handed or palpable illegal order which may be passed by the assessing authority. In this case, my lordship, the Honorable Supreme Court was examining the pre-deposit provisions. They upheld the pre-deposit provisions, but still they said that writ can still be maintainable if they find that the illegal is high-handed or illegal. So the contention of my learned friend that the writ petitions are filed just to avoid pre-deposit, the Honorable Supreme Court itself has stated that pre-deposit is not, it can't be said that a statutory remedy or that writ cannot be filed if the order is otherwise subject to challenge under Article 226. Then there are 4 more judgments, my lordship, where the Honorable Supreme Court has reiterated the contentions laid down in Whirlpool case. I'm not reading them, but they upheld the same contention. So, my lordship, in the interest of justice, this matter, in my humble submission, should go back to the commissioner. There are 2 reasons. First, he has demanded service tax on the entire component, where admittedly it's a works contract. On a sale component, VAT has been paid, and he has no jurisdiction to demand tax. This also I will show, my lordship, in a minute in the compilation itself. The first compilation which I had tendered, page 3 of that, first compilation.
Yes.
Page 5. Subclause 40, subsection 44 of section 65B, service. My lordship have that, page 5.
Yes.
Service means any activity. Definition of service, section 44. Service means any activity carried out by a person for another for consideration and includes a declared service, but shall not include an activity which constitutes merely a transfer of title in goods or immovable property by way of sale, gift, or in any other manner, or such transfer, delivery, or supply of any goods which is deemed to be a sale within the meaning of clause 29A of Article 366 of the Constitution of India. So this as per the constitution provision, Constitution 366/29A also I have enclosed, my lordship, at page 2. Last part, 29A, tax on the sale or purchase of goods. B clause, a tax on the transfer of property in goods, whether as goods or in some other form involved in the execution of a works contract. So even as per the constitution provisions, he cannot demand service tax on the sale component on which VAT has already been paid, and VAT is deducted by the government itself, because these contracts are awarded to be by the government, Ministry of Home Affairs. They have deducted VAT also on it. So 2 counts, he cannot demand service tax on the entire consideration, and on the service component, he cannot demand service tax even on the ground that it is covered under the mega exemption notification. Third point, my lordship, these demands are barred by limitation, since the government itself has issued me a letter stating that these services are exempt. Then how can the officer allege that there is suppression of facts by me with intention to evade payment of tax? Definition of service itself is clear. My lordship, serial number 9 is identical issue. It's only the service, nature of service which has changed. In that case, the services are provided to Irrigation Department of Government of Assam. Those are also covered by the mega exemption notification. Other than that, it is the same. And I don't have any letter from government in that case. In this case, I have a specific letter from government. But the order is almost identical to it.
Secretary, what product?
The services are provided to Irrigation Department of Government of Assam. That is also covered under mega exemption notification. That also I can just show one of you. The relevant contracts are at page 40. My lordship can see that these are the survey contracts awarded to be by Irrigation Department, Government of Assam.
Yes.
And then, my lordship, the compilation, I have enclosed the mega exemption notification in this.
Yes.
There is a compilation which is already submitted, page 23. Page 26, in fact, sorry, page 25, sorry, of the compilation, serial number 12.
Yes.
Services provided to the government, a local authority or government authority by way of construction, erection, commissioning, installation, completion, fitting out, repair, maintenance, renovation or alteration of canal, dam or other irrigation works, pipeline, conduit or plant for water supply, water treatment, sewerage treatment or disposal. So this is the exemption notification. In this case also, work order, everything I had placed before him, and he says the same thing, that you are not established correlation and all.
Okay. That's all.
Yes, my lordship, that's all, my lord. If my learned friend argues, then I can have some.
Yes.
I'm not on the merit of the case. I'm simply on the having alternative efficacy or alternative remedy. Decided by your lordship and as well by the by this court in division bench lordship. Lordship, the judgment I produced before your lordship that we to Aisundra. Similar facts were there. Their contention was that they were exempted. And after considering all this, your lordship felt that since there are alternative remedies available to them, they should avail themselves.
My lordship, the judgment which my learned friend is referring to is Shelja Constructors.
Mr. Counsel, please.
I just want inquiring, my lordship, that's it, because I'm not
No,
disturbing.
that is Ayasundra Hospitals.
Okay. So that copy has not been provided to me.
Section 86 is clear lordship.
Mr. Khan,
Lordship.
just one thing. Supposing somebody is doing a business which has got where this exemption notification applies, is he required to still take a registration?
Lordship, in my humble submission, rightly, suppose the order has been entirely wrong, Lordship. But the remedy is provided to them. They can avail that it will be corrected in course of appeal, Lordship. Lordship, it is not the case of the petitioner that they were not provided opportunity, Lordship. Suppose notice was issued to them, they filed their reply.
To answer my lordship, registration is not required. To answer my lordship, registration is not required. If
Let my
service
learned
is
friend
exempt.
complete, Lordship, then I'll give reply, Lordship. Let him complete his argument, Lordship.
No, it's a court query. You may
No,
proceed.
Lordship, that is different thing, Lordship. I have not raised, I have not disturbed my learned friend when he was arguing, Lordship. If he is anything, he can submit after completion of my argument, Lordship.
Yes, where is the objection in this case?
Lordship, in item number
9.
Lordship, I'm holding the 10, Lordship, but 9 also. Yes. So could not is at page 60, Lordship.
No, replies at page 65.
60, Lordship, thank you. 65. 65. Yes. I may receive your so-called notice dated so and so after that para 3 of your honor has mentioned about earlier letter, but no such communication has been even received by us. By me in income tax return file on so and so. It is true that I have disclosed gross receipt of rupees so and so, but simply on the basis of how it can be concluded that I have carried out taxable service. On fact, I am state that I am the government contractor mainly of irrigation department or government of Assam, whose contract receipt does not fall into taxable category. I am enclosing herewith copy of 26 AS and copies of the various orders of the department and request you honor to kindly drop the proceeding. Now let's say we come to so-called notice.
Page 60, paragraph 3.
Yes.
Thereafter, the said notice was requested by letter number so and so to submit necessary document, that is copies of invoices, issued calculation sheet of service tax, copies of ST3 return, income tax return, balance sheet, profit and loss account, etc. to the department, but till date, the noticee did not submit the required documents regarding this. Then in page 61, third paragraph. Paragraph, page 61, third paragraph, computation of service tax liability. From the scrutiny of the third party data comprising of income tax return, data provided by the income tax department, it appears that during the financial year 2014-15, the said notice had rendered taxable service amounting to rupees so and so on the value of service tax of rupees so and so, to be paid by the said noticee to the government exchequer. The noticee has failed to self-assess and declared the correct value of service tax payable and to pay the service tax, and hence same is required to be recovered from the from them under the provision of section 73(1) of the Finance Act, as amended by the invocation of extended period of limitation along with interest as appropriate rate under so and so. Then calculation is given. Then lordship below, contravention of provisions of Finance Act 1994 and the rules framed thereunder. From the above, it is this fact, it appears the said noticee has contravened the provision of section 69 of the Finance Act 1994 with Rule 4 of the Service Tax to 1994 as amended. Then 2, contravene the provision of section 68 of the Finance Act 1994 read with Rule 6. Then let's see next page. 62. Invocation of extended period of limitation under provision to subsection 1 of section 73 under the Finance Act. That reason also disclosed to him, but no reply was forthcoming also. Here is a noticee provided.
Just in page 62, you are referring to the extended limitation.
Yes, extended period of limitation.
Okay.
The so-called notice is very clear. All points has been discussed, and the notice was given to them, but they given a very evasive reply. Now they are coming with the documents that is exempted. Is what prevented them to place all these documents before the executive authority. In absence of documents or required documents which were asked for by them, and lots of seen number of times later were returned to them, but they were not provided any document. Now lots of argument has been placed before this honorable court that these things are there discussed. They could have placed before the authority at that relevant time. And where there is a specific provision for statutory provision for filing appeal, lordship, whether that can be under the circumstance, lordship, when there are two authorities, and our division bench also, lordship, in Silesia Commercial, lordship, Retail 188. The division bench clearly says when there is a statutory remedy is efficacy, statutory remedy is available, that they should avail that. Just because they have to deposit a pre-deposit, so that cannot be ground for allowing this petition, lordship. So under the circumstance, lordship, both the retribution are liable to be dismissed, and they may be directed, and lordship may condone the delay which has been committed during this period of pendency of this case. In earlier case also, lordship have given liberty. In view of the same, lordship, in my humble submission, since your lordship has taken view in the similar case, lordship, that should be applicable in this case also. Much obliged.
Lordship, I have some counter to make to the submissions made by Learned Friend.
Yes.
The letters which my Learned Friend has just read out in the show cause notice that I was asked to provide this data In the show cause, my reply itself, I had mentioned that these correspondences were not received by me. Now I will read the relevant part of the order also. Page 72,
Which writ petition?
serial number 9, my lordship. 2085,
Page?
72. Page 71, in fact.
Yes.
Para 2. In response to the said SCN, the noticee submitted his written reply dated so-and-so, wherein he stated that he disclosed gross receipts from contract as rupees 23 crore 89 lakh 41,323 in his income tax return. But simply on that basis, it cannot be concluded that he had carried out taxable services. He stated that he is a government contractor mainly of Irrigation Department of Government of Assam, whose contract receipts does not fall into the taxable territory. He also stated that he did not receive the earlier letters mentioned in para 3 of the SCN. There was my specific contention that I had not received the copies of these letters which my learned friend is referring. In the impugned OIO, nowhere he has provided me evidence of service of these letters. In fact, he has altogether skipped this contention of mine. And at para 3.8, he once again says that I was asked to provide the data and I have not submitted. Para 3.8, my lordship. I find that during the regime of self-assessment, the onus is on the service provider to correctly assess the service tax due on his own record. The correct value of services provided and the appropriate tax thereon have to be declared in ST3 returns filed. In the instant case, had the data from income tax authorities have not been available or scrutinized, it would never have been possible to know the actual gross value of the services provided by the noticee during the material period. I find that the noticee deliberately did not submit the documents to the range officer. He has not produced any evidence to show that these letters were served on to me, despite there being a specific objection raised by me, and is putting it on to me that I have deliberately not submitted the data. So that is to answer the first contention of balance. Second, my learned fund has read that survey, this show cause is clear that it demands service tax on the income tax. From where in the law he gets the authority to demand service tax from me on the basis of data reported under income tax. Income tax return I file as per the income tax provision. Service tax I pay as per the service tax provisions. Service tax provision nowhere borrows that the value of service has to be determined as per the income tax provision. I have produced before him the contract copies, which according to me was relevant. If he thought that these were not sufficient, he wanted some additional information, he should have informed me. There is a PH note also. I have enclosed, my lordship, 66, page 66. Page 66. This is my personal hearing note. I had mentioned again my submission. He has not mentioned anything here also that you produce so-and-so documents because I need. He has issued, first and foremost, he should have been clear in the show cause itself that on what basis he is demanding service tax from me. He should have given the complete picture. The Supreme Court and the Honorable Courts repeatedly in a number of cases have held that show cause has to be concrete. It has to be conclusive and nothing is permissible, anything beyond show cause notice. I have just to hold on, my lords. My lordship, the board itself has issued. There is a compilation in this matter also, my lordship. If my lordship have that compilation?
Yes.
Page 30. This is an instruction issued by the board itself. Sorry, my lordship, just a mistake. Page 63, sorry. It's my apologies, ma'am. The board itself has issued clarification in discrete show cause notices issued by service tax authorities. So board also appreciates that the officers are issuing survey show cause notices basis the data from the income tax. They have clarified para 2 and 3 in this regard.
Yes.
In this regard, The undersigned is directed to inform that CBIC with the instructions dated so and so issued with a file so and so has directed the field formations that while analyzing ITR TDS data received from income tax, a reconciliation statement has to be sought from the taxpayer for the difference and whether the service income earned by them for the corresponding period is attributable to any of the negative list services specified in section 66D of the Finance Act 1994 or exempt from payment of service tax. Due to any reason, it was further reiterated that demand notices may not be issued indiscriminately based on the difference between the ITR TDS taxable value and the taxable value in service tax return. That letter which is saying I have not received, he has not produced any evidence that I have received. So at least now I should be provided to substantiate this claim. There are multiple authorities, there is no High Court judgment, but there are tribunal judgments where it has been continuously holds by tribunal that service tax demand cannot be confirmed basis the data reported under income tax. So there is. Then my lordship, if my lordship can just read the show cause notice once again, page 60 of the writ petition. Para 2. Whereas, as per the third-party data received from the income tax department, it was found that the notice is providing taxable service. My lordship, basis the income tax data is even come to the conclusion. It does not say that it appears or something. It says it was found. So he has found a view also by issuing a show cause notice in the show cause itself. And then in the compilation, my lordship, I have also enforced the judgment of the Honorable Supreme Court, where in compilation, my lordship, page 81, Oryx Fisheries Private Limited, relevant part at 83 and 84. The Supreme Court judgment. Relying, my lordship, have that?
Yes.
Relying on the underlined portions in the show cause notice, learned counsel for the appellant urged that even at the stage of the show cause notice, the third response, my lordship, page, Oryx Fisheries, lordship, page 83, para 22.
Yes.
Relying on the underlined portions in the show cause notice, learned counsel for the appellant urged that even at the stage of the show cause notice, the third respondent has completely made up his mind and reached definite conclusion about the alleged guilt of the appellant. This has rendered the subsequent proceedings an empty ritual and ideal formality. The court finds that there is lot of substance in the aforesaid contention. It is well settled that a quasi-judicial authority, while acting in exercise of its statutory power, must act fairly and must act with an open mind while initiating a show cause proceeding. A show cause proceeding is meant to give the person proceeded against a reasonable opportunity of making his objection against the proposed charges indicated in the notice. Expressions like a reasonable opportunity of making objection or a reasonable opportunity of defense have come up for consideration before this court in the context of several statutes. The constitution bench of this court in Khemchand versus Union of India and others reported in so and so. Of course, in the context of service jurisprudence, reiterated certain principles which are applicable in the present case. Then these are the contention. Chief Justice S.R. Das, speaking for the unanimous constitution bench in Khemchand, held that the concept of reasonable opportunity includes various safeguards, and one of them, in the words of the learned Chief Justice, is an opportunity to deny his guilt and establish his innocence, which he can only do if he is told what the charges leveled against him are and the allegations on which such charges are based. It is no doubt true that at the stage of show cause notice, the person proceeded against must be told the charges against him so that he can take his defense and prove his innocence. It is obvious that at the stage the authority issuing the charge sheet cannot, instead of telling him the charges, confront him with definite conclusions of his alleged guilt. If that is done, as has been done in the instant case, the entire proceedings initiated by the show cause notice get vitiated by unfairness and bias, and the subsequent proceedings becomes an idle ceremony. In the second paragraph itself, basis the data from income tax is coming to the conclusion that I have provided taxable service, then my lordship, these proceedings are empty formality. These are the words of Supreme Court, and the similar views are expressed in Siemens versus the State of Maharashtra, page 74. Relevant part at 75. Relevant part at page 75. This compilation only, my lordship, page 75. Para 10. My lords, have that?
Page 74.
So page 74, it starts with relevant part at page 75. Para 10. Although ordinarily a writ court may not exercise its discretionary jurisdiction in entertaining a writ petition questioning a notice to show cause, unless the same inter alia appears to have been without jurisdiction, as has been held in by this court in some decisions, including the state of Uttar Pradesh versus Brahmdat, special director so and so, and Union of India versus so and so. But the question herein has to be considered from a different angle. When a notice is issued with premeditation, a writ petition would be maintainable in such an event, even if the courts direct the statutory authority to hear the matter afresh. Ordinarily, such hearing would not yield any fruitful purpose. It is evident in the instant case that the respondent has clearly made up its mind. It explicitly said so, both in the counter affidavit as also in its purported show cause notice. My lordship, the Supreme Court has also held. I have produced the clarification in one of the matters, letter from the government itself, Ministry of Home Affairs, which says service tax is not legal. And my lordship, assuming for a minute if I file an appeal, now I will produce these documents before tribunal again. These documents are not before the tribunal also. What they will do, they will also remand the matter back to the authority, because they also cannot give any finding unless the commissioner himself give any finding on these documents. So that should be done at this stage itself. When my lordship pre-deposits these, if these kind of notices are allowed to be proceeded with, many running businesses will shut down, because these are not some small amount that I have to deposit. I'm not like some big business conglomerate that I can deposit 1 to 3 crores and I can continue a business. My entire business will shut down. I have to take loan from the bank to pay all this pre-deposit. So better let this matter go back to him. Let him re-decide it in light of these documents now.
Let's see. Okay. Your name?
Arun Jain.
Arun Jain. Okay.
Yes.
Just right, Mr. Agent and counsel for the petitioner, and Mr. S.C. Kerala is standing counsel for the respondents. So the argument is otherwise concluded. On the issue of preliminary issue of maintainability, list on 2/6/2023 for delivery of orders or clarification, if any.
What's
Obliged.
should I let the book service?
Just give me that photocopy of that 74.
Not say me keep the book. I have another book. I'll take on second.
Just give me a photocopy, that will be all. Tomorrow morning, you can give it to the court master.
Tomorrow.
Tomorrow morning, give it to the court master.
Much of it.
Obliged, my lordship. Grateful to my lordship for allowing virtual hearing.
Next on list item number 2.
Yes, Your Lordship. The petitioner was an employee, 4th-year employee, my lord, of the erstwhile Winco, my lord, which was taken over by the ITC in the year 2013. Since 2016, my lord, for non-payment of wages, my lord, petitioner has been asking the authority to clear the wages, not having done, the petitioner had approached the appropriate authority, my lord, the learned labor commissioner. Ultimately, at the initiation of the labor commissioner, my lord, and what? Oh, no. 46. I will not go into the details, my lord. I may be permitted to place the order for Bakidai, my lord, at page 46. Where is the application of the dated in so and so by the applicant, in which it stated that the opposite party willfully failed to make payment monthly earned wages from 1/1/16 to 31/5/22, totaling 8,29,533. To the employed person violating the provision of section 3A of the Payment of Wages Act, and even the opposite party also deliberately failed to implement settlement arrived at through the conciliation proceeding held on 13/2/2017, violating the provision of section 18(1) of the Industrial Dispute Act, which are mandatory provision of the Act, for which the applicant compelled to file this application paying to the authority under the Payment of Wages Act for realization of the due of monthly earned wages, along with the 10 times penalty and compensation under the provisions of section 15(3) of the Payment of Wages Act. Where is the retainer? Opposite parties, my lord, the response number 8 and 9 that was represented before the authority, my lord.
No, I did not get it. You see, number one, you're now asking the deputy commissioner not to allow sale, correct?
Yes,
Who is going to sell it?
because they're going to sell by the response number 8 and 9. The ITC and the Winco, manager of the Winco, my lord. Because there is a provision in the that Bangalore Public Demand Recovery Act. my lord.
How does ITC come in?
ITC, my lord, the management of the Winco, my lord, it was taken over by the ITC in the year 2013. I have stated. No? Page 48, my lord. Copy to Amita Mohan, manager, Astral Inco, and Manohar Hussain, guard Inco. Now managed by ITC. We had also informed, coming to know that the sale permission has been granted to the ITC miner to sell the property, including land. The petitioner has immediately on the next day approached the deputy commissioner miner, page 51. Which happens, so I have to honor to inform you that it has been known from a reliable source that the management authority of ITC Dhubri has proposed to sell out and transfer the entire factory properties, including land of Wimco, to some buyer of Guwahati within very short time. That's our Baki that case proceeding number so was pending before the certificate officer. Who had already issued warrant of arrest under Bengal Public Demand Recovery Act against the Amitanda Mohan Datta, manager of Asapal Dhubri, now managed by ITC, authorized representative by ITC Dhubri in the district. The transfer of Wimco factory properties, including the land, is covered under encumbrance. In view of above, you are hereby requested to look into the matter and take necessary steps using your good office so that no unpaid earned wages amounting to rupees 82,98,000 so and so payable to the poor workman Manohar Hussain is deprived of in question. You have made statement in paragraph 18, no?
But this it would not be maintainable. It's a repetition against respondent number 8 and 9. They are not government.
But self-permission has been granted by the deputy commissioner. He is the authority, my lord, under.
No, for
the
that you see, unless
Recovery Act.
no. You see, that part is something else. But to restrain them from selling it, this is something which we cannot do. The Bakija authorities, they are not incompetent not to not entitled to do it.
Committed to read section 8 of the Bengal Public Demand Recovery Act. Problem, if necessary, I can hand over the page 725.
Yes.
From and after service of notice of any certificate under section 7, upon a certificate debtor, any private transfer or delivery of any his property, removable property situated in the district in which the certificate is filed, or any interest of any such property shall be void against any claim enforceable in execution of the certificate.
I'm not entertaining this repetition, but you see, insofar as the BDPR Act is concerned, it empowers the recovery officer to attach. That provision you will find in this Act Rule 40, Section 14.
Modes of execution.
Yes. So A is attachment and sale of any property. So if the recovery officer has the power to attach, then the High Court will not come in and give an injunction.
We may approach the Bakida officer, but in the meantime, my lord, we may be protected because if the sale takes place, my lord, how?
Because a writ cannot be issued against a writ cannot be issued against a
The Bakida
private individual.
the deputy commissioner. He is the authority, my lord, under section 33.
No. He is an
Two of
authority.
the Industrial Dispute Act.
No.
To recover the amount.
He is an authority under the Bengal Public Demand Recovery Act. He may be under the administrative control of a deputy commissioner, but he is an independent authority. He is a court for the purpose of recovery. And if he does not take steps, then you will find that his orders is otherwise appealable. And you will also find the power of the certificate officer goes beyond that. You see, number 1, section 17, property liable to attachment and sale in execution of a decree so and so be attached. So even it overrides the power of a civil court. Then it's been so long time that I'm reading is that
But here the certificate was issued to the collector, my lord.
it's okay,
For
but
recovery
why an injunction from this court?
Check.
Why an injunction from this court? If the certificate officer refuses to do so, then we understand.
It is not there. He has already issued notice to the.
No, if you don't
Warrant
file,
has been issued to the.
if you don't file an application there,
No, we have already approached the deputy commissioner by filing the application, my lord. Page 51,
page,
51. Since already Bakidai proceeding is pending against the same property, my lord.
no, page 51 is not an attachment proceeding.
The application.
It's a information you are wanting.
Yes, my lord.
No, it's not.
Oh,
an-
in the deputy commissioner, there is still already a
No, that-
Bakidai case
you-
is
you
pending
see,
where the notice has been issued.
You see, Ms.
So-
Bhargava Advocate, we can't stop you from giving letters to somebody. But the fact is that under the BDPR Act.
Without any inquiry,
the-
how the
under the-
deputy commissioner.
No,
is
you see,
self
unless,
permission to-
why not?
They-
You tell me why not? You
Because
tell me why
under-
not? If you see, if you don't give a restrainment order, can the deputy commissioner stop any sale? He can't do it. You can get a valid injunction and bring
It
it to
must be
the.
done surreptitiously.
No,
by the-
I'll tell you, it's very simple.
Even my-
I'll see, very simple. I have some personal enmity with Mr. Khan. Correct. I go to the deputy commissioner's offices and tell him, don't allow him to sell. I give a petition. Then tomorrow I am agreed by Mr. Vanik sitting behind. I go to the deputy commissioner and say that yes, he has a what do you call mention. Don't allow him to sell. Can I go on filing applications like that?
But what will be my remedy, my lord? Because if the
No,
property is
I-
sold in
I-
the meantime.
I have
partial
shown,
to the
I have
sale
shown you
commission.
the, you see, I can show you the remedy, but it is for you to evaluate. I can't do anything more. I have shown you the remedy. You will have to approach in appropriate forum.
Who will go before the authority, but in the meantime, who
No,
will be
no.
protected? At least
Not even for a
we
minute,
will be given some time, my lord.
not even for a minute. Then you,
Because tomorrow, if they execute the sale deed, my lord, the whole
You-
property will go. Then
No,
what
it will not
be
go.
my remedy?
It will not go.
Why?
Huh? There are provisions in the BDPR Act. Mrs. Burra, we are here to learn from you, not to tell you.
No, no.
Correct. Page 700. Page
Hello?
700. This power is at page 700. BDPR Act
725.
725. Huh? I have forgotten it long back. You are
We have
let me
been
read it again.
dealing with this matter after a long time, my lord.
You just read it that all sales should be void. You just read that.
Section 8, effect of service of notice of certificate.
Where is that?
725. Page 725,
725.
section 8.
Section 8.
Hmm.
So after that, it is void. So even if somebody purchases it, it is still void. They can't get any title when the sale is void. There is a difference between void and voidable.
The poor workman, my lord, he is
I
fighting
understand,
the
but
case since 2016
I
without
can't
any
do
relief,
anything.
without payment of a single penny by the authority.
I can't do anything. Third. This is U. Barwa, Lanet, Senior Counsel, assisted by Mr. S. Khan, Learned Counsel for the petitioner, and Mr. J. Handik Learned, Standing Counsel for the
I'm
Revenue
talking about a
Depart-
government law.
Revenue Department, also government advocate appearing for
3, 4, 6, 7,
respondent
4,
numbers
5,
3, 4,
5, 6, 7,
3, 4, 5, 6,
7.
and 7. And Ms. G. Hazarika, then government advocate appearing for respondent number 1 and 2. So Standing Counsel for Revenue Department appearing for respondent number 1 and 2. Next
I'm
one.
for government laws. I'm for government.
You're for others.
That's
1 and 2 revenue will still be appearing, 1 and 2 are for others. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has prayed for a direction upon the respondent number 4, I, the Deputy Commissioner, and respondent number 7. So the Deputy Commissioner, it is Dhubri, and respondent number 7, the Sub Registrar Dhubri Registry, to not allow for the sale of land at Vimco factory premises, Dhubri, by the respondent number 8 and 9 to any third party. Next paragraph. In brief, the case of the petitioner is that he has a against the order of his retrenchment, the petitioner had approached the labor court, and in course of the proceedings, the assistant labor commissioner had computed the amount payable by respondent number 8 to the petitioner at rupees 82,98,330. Full stop. For non-payment of the dues, the petitioner is approached the for recovery of the said amount. Bakijay proceedings was initiated under the provisions of Bengal Public Demand Recovery Act, 1913. Full stop. Next, the learned senior counsel for the petitioner has submitted that the petitioner has been agitating for his dues since the year 2016. And if the property of the respondent 8 and 9 is sold, third party rights would be created and the petitioner would not be able to recover any amount. Next paragraph. Having regard to the grievance raised by the petitioner, the courts of the considered opinion that insofar as the respondent numbers 8 and 9 are concerned, i.e. the ITC Limited and Shri Amitendra, AMITENDRA, Mohan Datta, DUTTA, they are not government within the meaning of Article 12 of the Constitution of India, and they are not performing any statutory duty. And therefore, writ against them would not be maintainable. Next paragraph. Insofar as the grievance raised by the petitioner is concerned, the court does not find that the recovery officer, i.e. the Bakijay, certificate officer under the Bengal Public Demands Recovery Act, 2013, is powerless to pass appropriate orders. Full stop. In this regard, the court finds that under section 8 of the said act, provisions are made regarding the effect of service of notice of certificate, and under section 14, out of various modes of execution, the certificate officer would have power of attachment and sale, or to arrest and detain the certificate data in civil prison. For the aforesaid reasons, the court is not inclined to pass an order which would have an effect to restrain the respondent numbers 8 and 9 to have sale registered. Under such circumstances, court is not inclined to accept that the Deputy Commissioner Dhubri or the Sub-Registrar Dhubri can be prevented from registering such sale. Nonetheless, the petitioner has a remedy to approach, and has an alternative remedy of approaching the certificate officer under the Bengal Public Demand Recovery Act from 1913 for an appropriate relief. Accordingly, this, with the observations as made above, this writ petition stands closed.